Good morning.
Good morning.
Okay, so let's get a head count because I feel like I'm expecting I know I've got one group that'll just sort of take everybody. I feel like poor Miss Akins and Mr. Bryan are probably getting ganged up on a little bit, but in separate parts. I see that we have a court reporter. So one of the things I'd like to do is figure out, has everybody arranged to figure out what takedown is? Is everybody agreed on takedown, et cetera? So the court reporter knows what she's doing because we technically have 3 cases before me today, but I'll admit in my preparation, because the school board's position is consistent across the 3 cases, it's likely that these are going to step on top of one another. And so have y'all discussed that? Is everybody in agreement on takedown?
We have not discussed it with the other attorneys, but we would like it taken down.
Yes, Your Honor. We did arrange to have a court reporter here. I believe that is Ms. Burns. Is that Ms. Burns? Yep. And so we'd be happy to share and take down with whichever other parties agree to that.
Okay. So the reason I ask, as I said, is that I suspect it's not going to be as clear cut as I'm going to call your case and she's going to take that down. It's going to end up stepping on everything. So just throwing that out there, given especially that I know we're dealing with some parties that may have more limited resources. So I'm also filling time while we get everybody on board. And on that note, I see that we have, well, let me just get, before we go on the record, let me just make sure I know who everybody is here, starting with the school district versus SC. Who do I have here on behalf of SC?
Randy Waldman, Your Honor.
Okay. And then Ms. Akins and Mr. Bryant, y'all are here on behalf of the school district. Is that right?
That is correct.
Okay.
And for the record, Your Honor, Mr. Chanda is here. That is SC's father.
Okay. And I recognized the name from reviewing the record. One thing I will tell you, anybody's allowed to attend, obviously, particularly those who have a vested interest. I am also live streaming this. So to the extent that we want to be 2 things, one, cautious that we are continuing to identify the students by their initials, as has been done consistently. It's probably me that will have to work on that more than y'all, because y'all probably do it all the time. But also, if too many people join the Zoom, sometimes it gets a little clunky. And so if you have the students or family members that want to observe and are not going to participate, they're free to watch on the YouTube link as well. Entirely up to them. Who do I have here on behalf of ES?
Your Honor, Chris Adams on behalf of ES.
And Ms. Akins and Mr. Bennett and Mr. Bryant, y'all are here on behalf of the school district for all 3 cases. Is that right?
That is correct, Your Honor.
Okay. And who do I have here on behalf of YH?
Your Honor, Stacy Kirschner on behalf of YH.
Okay, so it looks like we have everybody here. And so by virtue of it being the oldest case and the one with which I'm most familiar, because it was my case already before the other 2 got handed to me, I'm probably going to start with the SC case. But really what I'm looking for is just sort of a lay of the land, because as I see it, the code of conduct is consistent across the 3 students, the school districts, the hearing officer, the school board, and the state board, fairly consistent in terms of what happened. And that really, I am not getting down into the weeds, but really it seems like a lot of what the distinction here is factual relative to the different students' involvement and what to do with them and how the decisions might affect them. And I understand I am limited in my review to the record below. And so by saying all that, I don't mean to imply that I'm fixing to reach down and do things I'm not supposed to do, because I understand that I'm not supposed to do those things. Last thing I will say, and then we will go on the record, is I don't think it matters, but I just will let you know. I do not have any students at Fulton County School District, but I do have 2 students in the Atlanta public school system that are roughly the same age as all of these kids. So for whatever that's worth, I sort of know. I was very proud when I was reading some of the stuff about, oh, I know what this stuff means in Discord, because, you know, I have a kid who does that. So I have a tiny bit of institutional knowledge, but that's about it. I just wanted to let y'all know that I do have children around the same age as what we're dealing with. And I do have kids in a public school system, similar to what y'all are dealing with. So I just thought I would let y'all know that. With all of those provisos, Ms. Burns, we're going to go ahead and go on the record. This is going to be a hearing in the matter of the Fulton County School District versus SC, case number 24CV008693. The Fulton County School District versus ES, case number 24CV009720. And also the Fulton County School District versus YH, case number 24CV009721. I'll note for the record that we have counsel here that is the same counsel in each of the cases for the Fulton County School District, and then each of the students has their own separate counsel. And I'm going to start by asking Ms. Ms. Akins, because technically it is your petition, to go ahead and give me the general lay of the land, understanding that to the extent you can set that structural foundation, procedural foundation of where we are relative to all the students, I think that would be very helpful.
Sure, Your Honor. I did want to ask, though, kind of how we were going to do this in terms of just ordering and organization. Am I going to be permitted to make arguments, and then we'll have the Students' Council respond, and then I have an opportunity to rebut? Do you want to hear? I just want to make sure that I'm anticipating what you are looking to hear today.
Okay, well, unless anybody has a suggestion or wants to point me to, there's a particular reason I'm supposed to do it differently, because sometimes there is. What I was expecting is you guys as the petitioner, it's your burden to demonstrate that I should do, in this case, reverse the state board's decision. And therefore, I was expecting to hear from you guys first in terms of why you believe I should do that. And then I'll hear from the Students' Council as to why I should not do that. And then because you are the movement, you will get the last word.
Okay, perfect. That's what I just wanted to clarify. Thank you, Your Honor.
Okay, thank you.
Will it structure that way for each individual case, or do you want us to address all 3 individual from the outset?
So I think that what I'm hoping we can do is start with, I don't want to make you have to defend yourself 27 times, but I also don't wish to spend, I know I got announcements, 45 minutes here, 45 minutes there. The underlying basis, and I think, correct me if I'm wrong, but the underlying position of the school district is consistent across the students. And so I understand there are going to be nuances for each of the students, but to the extent the school board can try to address, I mean, to the extent that issues that are specific to each of the students' positions comes up, I will give you an opportunity to respond. But what I'm hoping is that we can sort of, at least at the outset, tackle it all at once.
Absolutely, Your Honor. I don't want to be repetitive, so I certainly understand. Okay, perfect. Well, I will jump in and get started then, if Your Honor has no other procedural matters.
Nope, go ahead.
I did want to make an initial sort of note on the record. We had filed a notice of filings to supplement the record that was not provided by the state board in both the SC and ES matters. So far, we've not received any objections from their attorneys about those supplemental filings, but I wanted to just know if on the record, if there were any concerns or objections to that, because obviously if we can't agree on the record, then we have a preliminary matter that we need to manage here.
So in the SC case, I saw that apparently Exhibit A3, which was the code of conduct, had been omitted from the record. And I saw that that was supplemented, and it was done, I think, last week.
Correct.
Forgive me, but I did not see if it's more recent, the supplement to ES, but what was the supplement?
It was, the ES hearing was split into 2 days, and the
Yes.
day 2 hearing exhibits were not included in the state board's record transmittal. And so we just supplemented with a notice of filing for those exhibits that the state board left out of their record.
I did see those. I just didn't realize they were part of a supplemental filing. Ms. Waldman, any objection?
No objection on behalf of SC.
Mr. Adams, any objection regarding ES supplement?
No, Your Honor.
Okay, go ahead, Ms. Akins.
Perfect.
Your
Thank
Honor,
you
if I
for-
could put one more moment on the record.
Yes.
I have had preliminary conversations with Ms. Akins regarding those records, which were not filed under seal, but which contain all sorts of identifying information. We had drafted a joint order to seal, but have not yet submitted that to the best of my knowledge. And so I think we will come back and do that at the end. I have, for any documents I plan to screen share, I have personally redacted all identifying information out of those. I would
Thank
hope
you.
that if Ms. Akins has the same, she would do that as well.
Well, because again, I'm sure there's probably 3 people watching this, but given you just never know who is observing in this day and age. And so we should all be aware of that. And obviously, unless anybody has an objection, if you submit to me a proposed order sealing, I will be happy to get that on file and get that taken care of.
Absolutely. Okay, great. Thank you.
I will, sorry, as a brief side note, I will warn you that our sealing process is a little clunky. And so it may end up being that the entire case is sealed, not necessarily that one item. So y'all should just be aware of that.
We understand that's no concern for us, and we certainly want to respect the family's privacy if they choose to do that. Okay. All right. Well, I will jump in. Thank you, Your Honor. I wanted to kind of get started by just reminding all of us the kind of discipline process and how this works for the school district. Whenever we have discipline hearings, they're not criminal trials. They're very simple administrative proceedings held at the school district. The strict rules of evidence do not apply in those hearings. Hearsay is allowable in certain contexts. The parties are not allowed to lay foundation or authenticate exhibits. And the reason it's structured and works that way is because our hearing officer is more often than not a lawyer. The assistant principal or principal that's presenting the case is not a lawyer. And then more often than not, the parent who's representing their child or the guardian is not a lawyer as well. So these proceedings really take on a very informal sort of structure. And as a result, you know, we want to take into context that we have to rely upon the evidence and the information that's presented during these hearings. And whenever a family is unhappy with a hearing officer's decision, obviously it is appealed to the local board. And local boards of education have wide discretion to determine why it's best, whatever is best for the schools whenever they take their action. OCGA 20-2-754 specifically states that they may take any action that they determine to be appropriate. And ultimately, the courts are not meant to second guess local boards. They're meant to defer to the expertise and the knowledge of the local board to know what's best for the management and running of their schools.
Ms. Akins, sorry to interrupt, but can you, while you're on that topic, address the issue? I know it was raised by at least one, I think several of the students, is this issue of the distinction between the board and the district for purposes of we have a hearing officer at the school level, and then the board is the one who makes the first review decision. And then it was reviewed by the students. It was appealed to the state board, and then it is the Fulton County School District that is filing this appeal. And I know there's at least one or petition for review. I know there's at least one student who has raised concerns about the appropriate party there.
Sure. And the local board is exercising this quasi-judicial authority in rendering its discipline decisions. A lower reviewing body like that cannot be the party for a petition review. The district is actually the aggrieved party here, as stated under OCGA 20-2-1160. And the district is who undergoes the daily management of schools and who's exercising that discipline and who is administering the discipline of students. There's a longstanding rule that only school districts, not school boards, are entitled or capable of being sued or of suing. We recognize that the State Board of Education lists the Board of Education as the appropriate party, but Frankly, that doesn't mean we should continue the bad habit. It's supposed to be the school board. It is always supposed to be the school board, but that's just how they decide to title their decisions. And, you know, if the court disagrees with that, we would ask that we have an opportunity to amend, not dismissal, because that is what is outlined in the appellate review process under OCGA 5.3-12.
Okay. Thank you for addressing that. I appreciate it.
Sure. Absolutely. But to jump back in it, so what we're asking this court to do essentially is to look at the state board's decision and determine whether or not it is reasonable based upon the evidence that was presented during this discipline hearing. And frankly, there is a wealth of factual distinctions between these students. And I know each individual attorney will kind of tell their client's story in their own way. But the reality is we have to look at what evidence was actually presented during the hearing itself. The state board is supposed to use what we call the any evidence test. That test has been around for decades now, and that is the state board's test for determining what is how they should review these discipline decisions and how they should move forward. And the role of the hearing officer is to determine, you know, which witnesses to give the most credibility, which evidence to rely upon, and to reach that decision. The state board, and frankly, all three of these decisions went well beyond their authority, and they reweighed the evidence, they reviewed the evidence, and made their own personal decision about what they think should have happened. They flat ignored entire pieces of evidence that were in the record. I certainly understand that they, you know, might not agree with the school district's decision, but that's not their role. Their role is to review the case and allow the fact finder to make those decisions and then determine, did the fact finder have sufficient evidence to even make that decision? And we would argue the fact finder in all three cases absolutely had sufficient evidence to find these students in violation of the code of conduct, of multiple violations of the code of conduct. And as a result, the state board should have affirmed the local board's decision in this matter. I can move to an individual student, but I do want to address one more sort of repeated argument, as your honor had sort of mentioned, that's, I think, relevant in all three of these students. And for whatever reason, the state board in all three decisions wanted to ignore the students' own admissions and statements about their conduct. That is a repeated error in all of these decisions. It is long settled that a student's admission to an administrator or a student's admission that's in writing on a student statement is sufficient evidence to support a hearing officer's decision and the local board's decision. That has been long established with the state board. The state board does not have the authority or discretion to ignore a student's admission or to disagree with a student's admission. They have to accept it on its face. That's what it is. And interestingly here, none of the students testified to provide any sort of alternative viewpoint. The students wrote admissions or they told administrators what happened, and the state board should have just accepted what those students said and then used that to weigh different pieces of evidence in the case as a whole. The state board just, in multiple decisions, simply decides that there is no admission, even though that's factually not true because the admissions are in the evidence.
Well, let me ask you this though, Ms. Akins, because I mean, I agree that's what the state board says is there is no admission of X, but it seems to me that part of what the state board was doing was saying there's no admission of, there was this, in all of the cases, I think, discussion of the distinction between downloading versus opening versus did it have to be downloaded from Fulton County or from its resources. And it seems to me that your interpretation is probably a fair characterization of what, you know, but it seems to me that another perhaps fair characterization is that what the state board was doing was saying, we read this rule to require X, and they didn't admit doing X. They might have admitted accessing the document, but they didn't admit downloading it from Fulton County. They didn't admit, you know, anything that would have been a specific violation of the rules that were asserted, particularly the one regarding the IFBGA. I can't even remember what that stands for. But the technology use agreements that have to do with Fulton County's data resources, et cetera. And the reason I mention that is I think it's pretty clear that the state board should not be second guessing factual findings made below it, just as I should not be. However, isn't it the state board's job to interpret what the rules are, what the code of conduct means? And is that what they were doing here?
I think I'd like to sort of answer you in two different parts here. First, I think the initial problem here is that the state board did not read the entirety of these rules. They just read what the individual rule said, but the rules actually referenced policy IFBGA. So we need to look at all of IFBGA. And they essentially admitted in their decisions that they did not explore and read the dozen plus pages of that policy to see if the student had violated the policy. They just read the one little sentence of the rule and determined whether or not the student had violated based upon what that one sentence said. They did not actually explore the policy. And that's the first problem here, is you have to look at the entirety of the rule, which incorporates the district policy, which incorporates that responsible use agreement, which incorporates the user device agreement, and incorporates those other documents. So whether or not the student violated the rule requires us to look at the entirety of that rule. So that's, I think, the first error that the state board made there. And second, the state board can certainly look at whether or not they can interpret the rule, but they do not get to decide that a fact finder's interpretation of the rule is wrong unless there is some sort of overarching constitutional violation or some bigger issue. They just decided to interpret it their way and decided that their way was the only way. And that's not reasonable either. The fact finder read the rule, and the fact finder determined that the student violated that rule and the meaning of the rule and what was included. Whether or not the student accessed, viewed, or downloaded is really sort of splitting hairs, because in many of these hearings, we didn't get into the depth of what the student did because the student didn't tell us. They didn't testify. We just have the statement.
But also because the school didn't actually do a forensic review of any of these computers to figure out if that information was there.
Sure,
and I understand we were 10 days in at that point. I get it, but.
Right. And the school couldn't. I mean, law enforcement agencies had those devices at that point. The school was not in a position at the date of the discipline hearing to even begin to do that. Unfortunately, they don't get to tell law enforcement that they need to do their own forensic investigation for a discipline hearing before the criminal investigation takes place. But the reality is we can rely upon what the students said they did. And if you take, for example, SC, she specifically states in her admission, and she told an administrator that the records at some point were on her district issued laptop. She wasn't sure if they were still on her district issued laptop.
Wasn't her statement more equivocal than that? Wasn't it just a statement that I don't know if the records are still on my computer, which I understand implies that they were there at one point, but that is something of an equivocal statement. It's not as if that statement was prefaced by, they were on my computer, I'm not sure they're still there.
But I don't think the equivocation matters here. They were on there at some point in time. She's admitting that they were on her computer and they never should have been, is our point. That would be a violation of the rule. If she had said, I never saw them on my district laptop, they've never been on my laptop at any point in time, that would be a completely different statement. But that's not what she said. She admitted that they were at some point on her laptop, and she was unsure if they were still on her laptop. And it is okay for the fact finder, the hearing officer, to make that leap and say, okay, they were on her laptop at some point in time. She admitted this. And then that was corroborated based upon her own statements to the administrators themselves. So it wasn't just a single statement. It was a conversation with an administrator about that as well. And so again, we have to just take those statements at face value, and the fact finder has to ask themselves, is that sufficient evidence to find the student in violation of the rule? Yes, it is. And that is the determination that the fact finder made. it's also an ongoing sort of argument or disagreement about jurisdiction in each of these cases. And so I would like to address that issue as well. The state board, for some reason, felt like the district did not have jurisdiction to discipline these students at all, which is frankly a bizarre sort of position when you consider the numerous cases in the background that the school district has jurisdiction whenever a student is utilizing the school's resources. That is accepted.
Forgive me, I don't think anybody's going to argue with that, right? Clearly.
Right.
But isn't part of what's going on here and why, at least part of the disagreement, is that all of the students, I think, consistently said in the lower, hearings that they were using their phones or their own personal laptops, not their school issued devices. And they were not on campus. It was not during school hours, and they were not accessing school resources, which the code of conduct defines as distance learning platforms, websites, or programs, right? So isn't that at least part of the issue?
Well, at first I would argue not all of the students said that. Their attorneys certainly made a legal argument, but again, we have to look at the facts of what was actually presented during the hearing. And there were not facts in the record to suggest that these students didn't necessarily use their school resources. We look at SC, she said she had the stolen records on her laptop, her district issued laptop, at a certain point of time. That is sufficient evidence to find her in violation of the rule and to find that there is jurisdiction in this case. And that is a distinction. I mean, again, there seems to be some confusion with the state board that simply because their attorney makes a legal argument about what happened, that legal argument is somehow a fact that we have to rely upon. That's not how this works. The students didn't, testify themselves. Some of them did have parents that suggested and provided some information, which I would presume the hearing officer, again, weighed credibility, weighed the different statements, considered each side, and made a determination based upon the facts. We don't know exactly what was going on in that fact finder's head. There's no way for us to know that, but they reached their conclusions based upon the record evidence. And we have to ask, is there information in the record, or are there facts in the record that support that hearing officer's decision? And again, there was here. And so the school resource that was most frequently utilized was their district issued laptop in certain circumstances for certain students. But it ignores the fact that the records that were stolen themselves are the resource. I mean, what makes, I think, this case complicated for us to sort of wrap our head around is these aren't physical documents that were stolen off of a teacher's desk. I mean, I think it would be easier for us to sort of understand that if these students had stolen, oh, looks like my camera went off, Your Honor. Not sure what happened there.
Well, I can still hear you, but
Okay.
I'd like to be able to see
hear me.
There
Okay,
you go.
good. All right, perfect. I think it would be easier for us if the students had simply stolen their classmates' records off of a teacher's desk and then they were passing sheets of paper, because that's easier for all of us to comprehend rather than this digital sort of world where they're sending records via, we don't even know what programming. There's a question as to how they were sending it.
Right, but also, I mean, test answers are I think that's a much easier understanding that test score answers would be a school resource as opposed to some unnamed student's disciplinary record.
Your Honor, I would strongly disagree with that, because the Family Educational Rights and Privacy Act tells us that school districts have an enormous obligation to protect student information. The school district as a whole has an obligation to protect student information. There are certain rules that the school district is under when it comes to disclosing information and how to disclose and who to disclose and who receives that information and what context. And it is federal law that protects student data and information. So test answers to me are not nearly as concerning as another student's records, whether they be discipline records, academic records, or anything else in their educational record. There's a lot of private information in a student's record, and no one should have to be worried that their classmates are going to get copies of their discipline records and then sit around and talk about them.
Yep, I don't disagree at all with that. I think my point was simply that test answers would be prohibited by any number of other provisions in the code of conduct, not least of which would be the honor code, which specifically prohibits cheating. And
Sure.
I think part of the issue here is understanding whether district resources, right? That nebulous term includes something like data that's never intended to be used student forward across the student body, right? It's isolated to one student and it's maintained for the benefit of the school district and or the school relative to that particular student.
Right. Well, and we would argue that the actual data that was stolen, those students' records, are the district's resource. The district created that document. The district is maintaining those documents and that information. The district is obligated to protect that information in those documents. The district is obligated to, follow all of the guidelines under FERPA with regards to student information. So it is a resource. It does belong to the district, except to the extent it belongs to the individual student it's about. And so it is a resource that gives the district jurisdiction to discipline students who steal or modify or download or use or have access to this information. That is the linchpin here that connects these students with regards to jurisdiction. And then once we know that there is jurisdiction to consider discipline, then we have to turn to the rules themselves to see if the students violated those individual rules. I'm happy to go through each individual rule with you for each individual student, but I also recognize that that is outlined in our brief. So I do want to talk about a few pieces based upon the brief that SC has submitted to the court and talk about some of the distinctions.
Okay.
Unless Your Honor would like me to go through each in-depth rule.
No, I don't think that you need to go through the in-depth on the rule, but I will say one reason I think you don't need to go in depth on the rule is that am I correct, right, that the 18E1 and 18I1, which I think was alleged to have been violated by each of the students, even if it was violated, would not rise to the level of the type of discipline that was imposed here, right? Because those are either tier 1 or tier 2 offenses. Is that right?
Potentially, yes. I mean, the district has some tier escalation policies, but that, yes, for the purposes of
and 22A2, which I also believe was it was assumed by each of the, it was asserted against each of the students. But 18B3 really seems to be where most of the focus is, right? And in terms of whether or not there was a violation of the copying and downloading unauthorized files, etc. If to the extent that you disagree, feel free to point out other ones like 22A2, which I think was found against ES and YH, but not against SC. But if you could sort of, I think it would make the most sense to focus most of our time on HB3 because, at least to my mind, that's the one that carries with it, particularly with the enhancement that was imposed by the school. It seems to me that that's the one where we should focus most of our effort, because if they were found responsible for all of the rest of them, I think it still wouldn't have risen to the level of discipline that resulted here, which is probably why we're all here, because of the level of discipline that was imposed.
Right. I mean, I presume, I'm not entirely sure if it's the level of discipline or just the discipline itself that they're unhappy with.
No, and certainly that's possible. But if you would, please go ahead, Ms. Akins. But yeah, I would appreciate it if you'd focus on that 18B3.
Okay. And this, kind of calls back to one of my earlier points is with 18B3, I think the state board in all three cases, particularly, and I can go into the individual differences, but with like SC, the state board ignored her own admissions and statements against interest here. Just decided unilaterally that she just didn't say that thing and it didn't mean what it meant. And that is where the state board erred here, because again, it's I don't want to sound repetitive, but it is a repetitive problem in each of these decisions. And it's a bigger problem overall here. And that the students made admissions, they made statements to administrators, and those statements and admissions support the hearing officer's final decision. And so in 18B3 for SC, she admitted that she downloaded records at some point on her laptop. They were on her laptop at some point in time. She was, willing to figure out and find them. I think we have a disagreement with the student as to whether or not she provided written instructions on where to find those records or an ES, but ultimately they were on her district issued laptop in SC. She admitted she'd had them for several months. I mean, I think that's an interesting point here as well, that SC didn't just get these records a few days prior to this incident and the investigation. She'd had them on her laptop for months. She admitted they'd been on there for months, potentially. That is concerning. And then, we get into some factual distinctions here in the SC. There's commentary about the documents that were stolen themselves were Excel files, and the likelihood that she probably viewed them on her laptop instead of a cell phone, because if you've ever tried to view an Excel file on a cell phone, it's pretty darn challenging. I mean, just being quite frank about it, it's hard to view an Excel record on a cell phone. So the likelihood of her being able to talk about and explain what it is suggests she probably looked at it and she had access to it and she reviewed it. And so we have to look at her admission as the sufficient evidence that finds that she is in violation of the rule. And then we can look even further in the rule, because we know, based upon the information that SC shared and that other students shared, that individual students' records were targeted here. And that's another concerning point. It wasn't as if they were stumbling upon random students' records. It was specific students they had a history with, students they had a problem with. There was some sort of targeting of individual students' records.
Well, in fairness, hang on. So I think that probably is the record relative to YH, right? There might be some documentation that there was a low-key beef, as my teenagers would say, between perhaps one of the students whose stuff was stolen and YH. I don't think I saw anything in the record regarding ES or SC having specific connection to the students' records who were taken.
Well, the administrators testified during the hearing that the students did seek out specific students' records. And we don't
sought out specific students' records.
Well, that's where it's unclear in the record. Is it GS that sought them out, or is it GS that sought them out and then SC asked for those specific records or were interested in those specific students? We don't know, but we do know there was an interest in very specific students. And I'm just simply stating that that is another part of this rule that we can take into consideration here. We've already established that her admission is enough to show that she violated the rule. But this, when you couple this concern about what was the intent, what were they trying to do? Were they targeting specific students? Was there a bullying harassment component? We would argue there was. What were they trying to accomplish by talking about and participating in this conversation about these student records? We'd argue that there is some sort of harassment or bullying component here. The school district just found out soon enough to hopefully have stopped all of that. But that is a piece that was entered into the record, so to speak, via witness testimony in all three of these cases. And I agree that in YH, there seems to be a more consistent story in terms of YH clearly had some sort of specific issue with a personal beef. It sounds as though ES and SC, based upon the testimony that was provided, did not like these other students and had a history with them. And so I think that is relevant because we can't ignore that these weren't random students' records that they had obtained. These were students they didn't like or that had issues with them.
Okay.
And so that, again, sort of supports why the students were in violation of the rule. I know in SC's brief, when it comes to the part on 18B3, there is a lot of conversation about downloading versus viewing versus accessing and what does that mean. And the reality is the hearing officer listened to the testimony, the hearing officer reviewed the admissions, or the written admission, and made a determination that based upon their reading of the rule and what the student said and what the administrators testified to, and then what other information was presented, that was sufficient enough to violate the rule. we did not have testimony from the student about exactly whether she downloaded or accessed. And I'm not sure. Without a forensic investigation, we will know, because it sounds like if you listen to or you read the transcript, everyone disagrees about what downloading even is. And we get into, a discussion of that in the brief itself. But again, we have to look overarching. The fact finder reached the conclusion like, yeah, they downloaded unauthorized files. They had access to these unauthorized files. That's enough in order to reverse the state board's decision here.
Well, and that may be part of the distinction potentially between SC, at least the facts that were presented relative between SC versus ES and YH. But as to SC, I mean, setting aside this idea that it had that this argument, I know that's in the briefing, that it had to come directly from the district, right? But isn't part of the issue relative to SC that, I mean, again, we're all operating at a significant, at least I am, I know, and I've heard several say, at a significant technological disadvantage. But certainly the idea is I can be sent things that I don't then actually access or open or download. But they would, if someone went and looked at my computer, it would still appear that they were there because somebody sent it as an attachment to my email. And so I think at least one potential distinction between SC versus ES and YH is that even if you acknowledge the school's understanding of the rule, right, and say that it doesn't have to come directly from the district, it was a resource in and of itself, and whatever, you still have to demonstrate that it was downloaded or accessed. And there's really, other than that equivocal statement in her written statement that says, I don't know if it's still on my district device because I opened it on my phone. What evidence is there that she actually opened it or accessed it? That's what I'm not quite sure I understand. And I think I understand your position that whether it was on her district device or not, the statement that she opened it on her phone is enough to demonstrate, to support the finding that she violated the rule by downloading or accessing that document, which was district resources.
Yes. I mean, I think I would just take a different position that if you've opened the document, you have downloaded it. It might be locally to your cell phone or your laptop or whatever device you're using, but that is downloading. It has to actually download in order to read that document, whether it be an Excel file, a PDF, a Word document, whatever structure or that it was in. You had to download in order to look at the document. And for her to even know that it was on her district issued laptop at a certain period of time also suggests she opened and looked at it to confirm what it was. That's enough to show that she downloaded unauthorized files. She knew they were unauthorized. I don't think there has been any sort of question that any of these students don't understand that they didn't know that they shouldn't have had access to other students' records. They're all extremely bright students. They all absolutely understand how records and student privacy works, in the sense that they're not supposed to have access to their classmates' private discipline information. And so she knew that they were unauthorized. Again, that is sufficient evidence to show that she violated the rule. We don't have to really dig any further. And the fact finder may have, may not. Again, we don't know exactly what the fact finder's determination was, but they probably looked at it and said she viewed it on her cell phone, which she admitted to. We know that was downloading. She viewed it at some point on her laptop, which meant it was downloaded, and that's enough to show that she violated the rule. Then turning to just kind of to group 18EI and 18I, the state board's sort of overarching problem with both of those rules in SC was that it just flat ignored the district's policy. And that's concerning on multiple levels, that they just did not read IFBGA, it seems.
Well, let me back up for a second. Forgive me, Ms. Akins. Sure. I agree we need to have a conversation about 18I1. But right. 18E1, I mean, it really does seem to be directed at student who pulls out their cell phone and won't put it away when directed. Um, i- is this, are you disagreeing with that assessment of 18E?
Absolutely.
Okay.
18E specifically states that it includes the entirety of policy and operating guideline IFBGA responsible use of the technology or enterprise technology agreement. So you have to look at the entirety of that policy to determine, are there commands or instructions from the district to students who are using their resources or have access to their network? And the answer to that is yes, there are instructions to students in that policy and the operating guidelines. So was the student in violation of that rule? Absolutely. I mean, on its face, they just demonstrated irresponsible and unethical use of technology. But if we want to look at it even further, they, again, accessed information that they did not have permission or authorization to access. And they downloaded it and they used it potentially for, personal reasons or personal gain. And then when we look at 18I, it's about the clear violation of the responsible use agreement. And in there, it specifically says that folks that are non-employees of the district should not have access to this information. And it's pretty straightforward and simple. And the students, all three of them at some point had access in various ways, and that they knew that they shouldn't have had access. So that is a violation of policy IFBGA. And that is why they violated the rule.
Where, like, and I know I'm not questioning that it is there. What I mean is that it is, I don't know, a 5-6 page portion of the code of conduct. What specific provisions is the school district's position that was violated?
Sure. There is a specific provision, for example, in there that states that district resources includes district issued laptops. We know that these students knew that they did not own their district issued laptop, that they would have to return it, and that it is subject to the district is loaning them to use it, but they knew that those laptops did not belong to them. And so they were required to follow the district's rules regarding the district's resource. So that's the first piece on there. And so we, can look at the next, kind of turn to a few pages later, and we can pull out a copy of it if we need to. But IFBGA specifically states that the student records should not have been accessible to non-employees. Like, non-employees is the terminology it uses. Students are not employees. They do not ever have any access to other students' records. And SC admitted to receiving, she admitted to accessing, and we would argue she admitted to downloading those student records and viewing them. That means that she was violating policy IFBGA. And then, interestingly enough, she knew that she didn't have permission to view those. Like, there's commentary in the record about whether or not she knew she should or should not have had those records. And then further in the policy IFBGA, it also states that district resources cannot be used to bully and harass other students. And again, we would argue that there was evidence that SC, as well as the other students, were interested in targeting specific classmates for their discipline records. And that would be a violation of the policy.
I understand, but I mean, that's akin to attempted harassment. I mean, maybe that was their intention, but there's no indication that they acted on it. There's no evidence in the record that they acted on it. So let's focus on the fact that they had it, just other than what they might have used it for, if they ever got around to doing anything with it.
Okay.
And forgive me for interrupting for Ms. Eggins for 1 second, which I've done a number of times. Can I take like a 2-minute break and get some more coffee, and then I will be right back?
Of course.
Thank you.
Thank you.
Thank you all for that brief interruption. I appreciate it. But I apologize for the interruption, but I am ready to resume. I think where I interrupted you is we were talking specifically about the IFBGA and the particular portions. You were pointing me to the provisions that you believe were violated here in terms of responsible use of the devices, et cetera.
Right, correct, Your Honor. And, you know, we go through the individual page numbers in our brief of where those specific violations are. I'm happy to pull them up for the court, but I also, you know, recognize that I've outlined them quite specifically for you in the brief. And so I'm trying not to be repetitive to the extent I can here and be cognizant of our time. But again, I think that the bigger point for us is when you read the state board's decision, when it comes to that rule, it shows that they did not review policy IFBGA at all. There was no consideration of what was in there and the entirety of that rule. And, you know, even in their response in their brief, SC sort of glides over the entirety of that policy in their response. They don't raise any of those specific provisions and how the student did or did not violate them. They just look at the substance of the code of conduct rule and don't look at what it's actually referencing. And I think that's relevant here. And then, of course, for SC, the 22A2 charge was dismissed by the hearing officer, which I think is relevant here as well, in that the hearing officer was clearly looking at all of the evidence and felt like, well, the school did not provide sufficient evidence for the student to have violated that rule, and they dismissed it. So it wasn't even like
right. No, I mean, I agree, but also because there at least was, to the hearing officer's way of thinking as to, and this may be the right place to transition to ES and YH, right? There was no evidence that SC, I think we can agree, no evidence that SC was involved in the alleged cover-up. You know, as they say from Watergate, the cover-up's always that's always going to be what gets you. But that allegedly where that 22A comes from applicable to ES and YH is this argument that they were cognizant of and in directing people to delete information.
Correct. And there isn't evidence that SC was asking for information to be deleted. So, you know, I think the hearing officer to a certain extent made the right decision there and looked at each rule individually, weighed the evidence, and made a decision that was best based upon the facts that were presented at the discipline hearing for that student. And so I think that's kind of where I would leave SC at this point. I can transition and talk about some details with ES if Your Honor would like. Would you like to hear from SC's attorney instead? How would you like to?
I think I would like, and again, I'm going to give you an opportunity to go into more detail, but I think it would be helpful to go ahead and address ES and then YH, and then I'm going to call on their attorneys in that order.
Okay. All right. Well, I will turn to ES then. And I think the kind of important or relevant facts, just to kind of ground us in the situation for ES, is that she told an administrator that she received and downloaded student files to her district laptop. She knew that those files were hacked and stolen. There was a reference to her having access to those records for several months. Again, I think that's important because it wasn't something that just happened within this 24 to 48 hour period. She clearly had access to these records for a period of time. There was testimony in the record that the stolen records involved a student that was disliked by Emily or ES and her friends. And so there's that sort of point that we have to consider. And then, of course, once the district started investigating, ES was involved in deleting evidence of her rule violations. She encouraged others to delete evidence. And she participated in this sort of cover up in order to distract or hide what had actually happened from those that were investigating. And I think that's, again, an important relevant fact here. The argument with regards to jurisdiction is essentially the same here, in that it's a utilization of district's resources, whether it be her district laptop, or we can look again at the argument that the district's data is its own resource here. Comes Again, the stolen records are property of the district. They were created, maintained, and controlled by the district. They are the resource that is at issue here. Therefore, the district had jurisdiction to discipline ES. And then we turn to 18B3, which I know you've mentioned is kind of the bigger rule for a lot of these. And it comes back to ES's own admissions and statements, and whether that information is enough for the fact finder to have concluded that ES violated the rule. I mean, and you know this as a judge yourself, but there are a lot of interpretations. I'm not questioning the interpretations that are available here. I'm just pointing out that the fact finder's interpretation of the rule and the evidence here is reasonable, and that is enough to find that the student violated the rule, and that should have been enough for the state board. And for reasons that are completely unknown to us, the state board just disagreed, it seemed like, with the outcome here, rather than looking at the record evidence. And so when we look at 18B3, we know that she told an administrator that she downloaded these records. She provided some handwritten notes of where to find the stolen records. I think there's a disagreement from ES's perspective as to what those handwritten notes went to, but she provided handwritten notes of where to find the stolen records. There was no question that they were stolen and that she downloaded them and where to locate them and how to find them. We know that she admitted in the messages that she exchanged with one of her classmates that she was aware how the hacking took place. She knew there was some hacking that was taking place. She knew that they weren't supposed to have the records. She knew that her actions in keeping those records was wrong. I mean, she knew and admitted to all of that in her own statements exchanged with another student. And then she ultimately admitted to the administrators, Mr. Kent and Mr. Quarashi, that she destroyed essentially the evidence of her own rule violations. And again, we also look at the fact that ES targeted specific students' records, and that is essentially evidence that she was likely using this for personal gain and that she wanted to either bully, harass, or gain advantage over one of her classmates. Why would she be interested in any specific student's records if not for her own personal use? And then the deleted evidence aspect of this, she knew her conduct was wrong. She was aware that she wasn't supposed to have access to those records. All of that information, when you consider it as a whole, we have to ask ourselves, is it reasonable for the fact finder to have concluded that she violated the rule? And we would say, absolutely. That is sufficient evidence to show that she violated the rule. Therefore, we can turn to the next rule to determine whether or not she's violated that. ES was the only student that was charged with Rule 18C3. It was a little different in that it was a question as to whether or not she was trying to steal private property or school property while using student resources. She admitted to downloading and maintaining the stolen records on her district-issued laptop. She admitted to having it for several months. We would argue that by her granting moderator privileges on the Discord channel to other students, that she was acting, frankly, somewhat cavalier with what she knew were private records. She, asked people to cover it and gave them access to information that they may or may not have had access to beforehand. We don't know. But the reality is she was more concerned with covering up what she'd done than with being considerate about the seriousness of the records that were stolen and that she had access to. Her ultimate goal here was just to protect herself. It wasn't to consider the seriousness of what actually happened here and protect those records moving forward. Again, then we move to Rule 18EI. Once again, the state board essentially ignored the entirety of the policy and operating guideline of IFBGA. There's no discussion or consideration as to whether or not those students violated the policy. it's like they just didn't read it, frankly, is the perspective I get when I read their decision. They just did not look at that or read that. And so there's no consideration as to whether or not, well, the hearing officer did. The hearing officer read the entirety of the rule, read the entirety of the policy, the operating guideline, and determined there was sufficient evidence that the student had violated it. The district resource in question, the district issued laptop, as well as the district data itself is a resource. And then we consider the fact that, I think we can all somewhat agree that this is irresponsible and unethical use of technology. That is a very clear statement in the policy, is that students should not be engaging in irresponsible and unethical use of their technology. There was testimony in the record that ES had taken a digital responsibility course. So there's really no question as to what she understood about the seriousness of this, probably as exhibited in her text messages with her friend. She knew what she'd done was incredibly wrong. She knew that this was incredibly serious. She knew it was irresponsible and unethical. She knew she was not permitted to have the records.
So again, though, what I need to make sure I understand the distinction is that no question GS, if he's the one that accessed the records, downloaded the records, and began disseminating those records, that he accessed the school's enterprise network and obtained these materials that are clearly confidential, et cetera. I guess what I'm not understanding is, I understand your position that the students, some of their statements indicate they used their district issued laptop to conduct these activities or to receive the information. But is your position that even if they'd used a personal laptop or a phone, not their district issued device, that it would still be a violation?
Yes, Your Honor.
Okay.
Because the stolen records themselves are the district resource. The district resource is the data that they created, they maintain, they control. That is enough. I'm just pointing out that there's even more evidence in the record, and that ES used her district issued laptop, which, even if it's so clear that she violated the rule, because not only is she inappropriately having access to and using and downloading the stolen records, she's using district resources in order to conduct that irresponsible behavior.
So,
and that
the reason I keep going back to this is I understand that your position initially is that there is facts, there is evidence in the record that the state board ignored, that at least ES and YH, and to your mind, SC as well, used their district laptops. That's one issue. But I think where I'm getting bogged down is that I think you keep referring to school data as a resource. And I think I understood that argument when I was reading the briefing to be an explanation of why there was jurisdiction. But if that's the case, that would be different, though, than the argument that he used for example, YH used school technology resources for personal gain. But school technology resources is defined in the Code of Conduct as distance learning platforms, websites, and programs. And that's not personal disciplinary records that the school maintains for its own benefit, not for student access or use.
That is what it says, but Your Honor, I'd also say again, in policy IFBGA, it extends that definition to include other resources that are owned by the school and controlled by the school. It's not limited to that definition. We have to look again at the entirety of the policy and operating guideline of IFBGA, because it is incorporated within the Code of Conduct rule. And I think your interpretation is exactly what the state board did here. And that's our concern, is that the rule incorporates the entirety of that policy. And so we have to look at every page, every sentence of that policy when determining whether or not the student violated the rule. That is what it states. And I don't think the state board did that. I think they read just that one sentence of rule, 18EI or 18II, and just said, okay, refusing to comply with reasonable directions or commands. Like, they just sort of stopped. They didn't consider the fact that the entire policy and operating guideline of IFBGA is included. And so we have to look at all of the definitions within that. And there are parts of IFBGA that don't apply to students. I mean, we'll be the first to say, like, the entirety of the policy is not all about students, but a lot of it is. It's about any user of district data, any user of district resources, and that would include students at times. The stuff that is specific to, I think there are some instructions to the superintendent in there. Obviously, that wouldn't apply to the student, but there are instructions to students and anyone who is using or utilizing district data. I mean, that would include visitors that walk on campus and connect to the district's Wi-Fi network. They are now subject to that policy in theory, because they're a user of a district resource or a network or a device of some sort. That is what the policy encompasses. And so we have to look at the entirety of the policy. And there is sufficient evidence to show that a fact finder could interpret the evidence as the student violating that rule. And that's, again, really the only question we should be asking ourselves is there sufficient evidence? Is there any evidence that supports that hearing officer's decision? And we would say absolutely.
Okay, let me ask one more question about sort of, I mean, obviously in reading the records, right, I was educated that there's a bifurcated system where the hearing officer looks at whether or not there's a violation. And then once they decide there is one, then they take evidence regarding the discipline that will be imposed. And one of the things that, so, I mean, whether there was or was not a violation, I feel like I have the right tools and understanding to say, was there any evidence to say there was a violation of a specific provision? What about the discipline that was imposed? What, if any, role do I have in determining whether there was any evidence? Let's say, for example, let's say that, I mean, obviously my job is to review the state board's decision, and primarily the state board's decision was to reverse the school board. The school board's decision was not just to affirm the hearing officer's decision, but also to add this provision that they could not re-enroll in the Innovations Academy. What responsibility or authority does the court have if it were to, for example, determine that there was authority to or there was some evidence to find that a violation had occurred, but not any evidence, justification? I'm not exactly even sure what word that would be, for the school board's decision to change the discipline that had been imposed by the hearing officer.
Right. Well, as I mentioned earlier, the local board has wide discretion to essentially make any judgment it would like within reason once it is appealed to their level. And so the local board's decision to add or change or modify the discipline was allowable at that stage. And they took different approaches with all three students, as I'm sure you saw. They decreased the discipline in some situations. They, maintained it in another situation. I mean, they looked clearly at each of them individually, and really determined what they thought was most appropriate. In terms of the court's authority here, according to OCGA 5318, it states that essentially you can affirm, reverse, vacate, or you can remand back to the state board with further instructions. And so when we consider at the state board level, when looking at discipline, the state board, by and large, allows school districts to assign discipline based upon what they think is most appropriate. They rarely, if ever, say, yes, the student violated the rule, but the discipline was inappropriate. It is in extreme circumstances where that has happened. They do not bother or mess with the discipline that the school district imposes because, one, students are put on notice about what sort of discipline they may receive for each of these rules. And so the students are aware in the code of conduct of what this could look like. The state board should not be determining that a school district's, decision of a tier 1 or a tier 2 or a tier 3 or 4 or whatever is or is not appropriate. That's not their role. They're just determining whether or not it was in line with the code of conduct and what sort of discipline, was appropriate in those situations. But there's also a point here that we need to consider, that if the students are requesting any sort of specific outcome or relief from you, they need to identify any sort of express authority, essentially a waiver of sovereign immunity for that relief, because all you can do is reverse, affirm, vacate, or remand for further instructions. So if they're asking for any specific outcome here, like trying to attend a specific school, then that is outside the court's jurisdiction for the purposes of an administrative appeal here today.
Right. And that's actually why I asked the question, because I don't necessarily disagree with you that ordering them to be readmitted to the program or something like that is probably outside of my purview. I guess really my question is, we've spent all this time talking about there's evidence to support the violation of the code of conduct, therefore subjecting them to discipline, right? That's the position that y'all have taken. What I'm questioning is, what is the standard? And even if it's wide discretion, they're still, so is it that it has to, that their decision, if I were to take issue with it, it would have to be because there was an abuse of that discretion, because the discipline imposed was arbitrary and capricious? What is the standard?
Essentially, yes, an abuse of discretion. And there is no evidence that they abuse their discretion in any way here. The school board's discipline was reasonable in light of the discipline outcomes that are possible within the code of conduct. And then the school board determines enrollment at specialized schools. All of these students are being provided with an education. I do think it would be, I think we have to have a different conversation if the students have been permanently expelled and were barred from attending school. I think that is a different conversation than what we're having here, because these students are being permitted to obtain an education. They can work towards graduation and their diploma. They can still walk across a stage to graduate. It's just a question of, are they going to get to take perhaps a specific class or a specific opportunity? And the district
let me make sure, forgive me for interrupting. Let me make sure so I agree with you on CS SC, that's true, right? She was given the opportunity to attend her locally zoned school for this school year. And YH was allowed to attend his locally zoned school starting this school year. But ES was not allowed. She's still expelled, or whatever. I guess expelled is the term that's used because it's longer than a long-term suspension, through December. So barring attending the alternative school, which there's some discussion about the perhaps inappropriateness of that academic setting for these particular students. What about ES? Where is she? You mentioned that they're still getting an education. Seems like that would be that's true probably for SC and YH. What about ES?
An alternative, the district's alternative school is required by state law to provide students with credit-bearing courses to allow them to graduate from high school.
Right, but we all understand that. I mean, I absolutely understand that, and I don't quibble with it, but we all understand that the typical student that is attending the alternative school does not have a 97.8 GPA and multiple AP credits and planning to attend college perhaps. And I'm not saying that student has to be catered to in that way, but I am questioning. Really, my issue, my question was this, to be clear, Ms. Akins. You said these students are all still being given an opportunity to be educated. My question was directly to ES. Do we know what ES is doing? Is she attending the alternative school, or has she chosen an alternate? What is ES's position currently?
As far as I'm aware, I don't believe she's attending the alternative school right now. When I last touched base with the alternative school about enrollment, I'm quite certain her attorney can probably provide a little more insight on that.
Okay.
But I would really disagree with the court's statement that they're not a typical student, because the typical student that attends the alternative school is a student who has violated the code of conduct. And we treat students as equitably as we possibly can. And I think it is concerning to say that a student, simply because of their GPA or their personal home circumstances or anything else should be treated differently than any other student at Fulton County Schools. That when students violate the code of conduct, they received consistent, equitable discipline. And that is what she is being provided here.
I don't disagree. And I simply was pointing out that if the reason we have all these AP programs and IB programs and Innovations Academy is to educate students up to their ability. And I was simply observing that perhaps the alternative school is not positioned to educate these particular students up to their ability.
Sure.
Right, wrong, or otherwise, it doesn't mean the school's not providing. All of that was a long way of asking the question, where is ES and what is ES doing? Because she is still expelled until December of 2024, correct?
Correct.
Okay.
Right. She can return to her home school in January, according to the discipline order from the local board. I mean, I think just for consideration and kind of context here, students at Innovation Academy are absolutely provided with all of these incredible opportunities. But one of the many opportunities is working with, they have internships and programs working with outside partners and businesses and companies. And so we are questioning whether or not a student who has already shown irresponsible and unethical use of data that she received about another student, and whether or not she should be provided with opportunities to obtain potentially private and confidential information from partners and resources within Innovation Academy. And there's a bigger, I think, issue here as to what led perhaps the local board's decision here and whether it was appropriate for each of these students. And at the end of the day, we look at the discipline and whether it's reasonable. The local board had wide discretion. They exercised their discretion. It was not an abuse, and it was appropriate under the circumstances here.
Yeah, I think the only reason I question it is I don't necessarily disagree with you that innovations, and I think we discussed this at the original hearing we had regarding SC, perhaps is a privilege. I just question whether sending them to the alternative school, if you're going to expel them from that program, which is what the board did, essentially. They were already long-term suspension, and then basically said you cannot return. Then why not just send them back to their zoned school instead of saying you must go to, and again, I'm sure that's outside my purview, but it's just one of those questions of judicial interest, I guess.
Sure. And I understand that. I think the district's kind of position on that is we treat students equitably, and all students who are expelled or suspended are within reason given the opportunity to attend the alternative school. It looks different in certain situations. The alternative school has its own programming, and I'm not the director of the alternative school, so I can't give details about that, but students are treated equitably and consistent across the district. And when you're under an expulsion or suspension, you attend the alternative school. And that's exactly what we're asking of ES at this point.
Understood. Thank you, Ms. Akins.
Of course.
Okay. So are we at a stopping point from your position? And so I can transition into hearing from the students' attorneys.
We can certainly do that. I haven't gone into the details of YH, but I know we have discussed YH multiple times and some of those differences. So, I'm certainly happy to kind of hold off and just respond to them specifically at this point.
Okay.
I did want to mention there have been some objections in what I read of the briefs that were filed last night, as well as what has already been filed, that there were some objections to some of the issues in our petition for review. And so we just want to kind of point out to the court that if there are any defects, we would ask for the opportunity to amend that, because that is what is outlined by the statute.
Right. I mean, that I am aware that's one of the reasons I asked you about the issue of the proper party.
Right.
I mean, obviously, one of the main reasons that the consolidated appellate review statute exists is to get rid of some of this, the older system where if every box wasn't checked, every T crossed, every I dotted, it was fatal. But I will say most of what I reviewed, I'm not prejudging if you want to argue differently, but most of what I reviewed in terms of the procedural issues, not only would be amendable under the new structure, but probably would have been an amendable defect under the certiorari structure. So, take that for what it is.
Absolutely, Your Honor. I just wanted to put that on the record, so to speak.
Understood.
Okay.
Ms. Waldman,
Yes, Your Honor.
please go ahead.
Your Honor, let's put this in context that perhaps those of us who aren't 16 might understand. I'm speaking only for myself. Imagine it's the middle of your day, you're rushing between meetings, and you open an email sent to you from someone at work, someone you know and trust, and you don't think twice when you click on it. It's not what you expect. It's a confidential file not meant for you to review. Now, we're on a Zoom call, much like the platform we're on right now. Like Discord is a virtual meeting. You're not paying attention. You've turned the video camera off. You're on mute. In the background, your colleagues start discussing confidential information. You didn't know the conversation would take place before joining the call, nor were you actively participating in the conversation. But you can't unhear what was said by others. Under the local board's theory of law, you have violated the Fulton County Code of Conduct. And you would be suspended and then permanently banned from the opportunity you worked your whole life to achieve. At its core, this case is about SC's innocent conduct being shoehorned into a code of conduct violations that are, quite simply, inapplicable. Quite like the examples I just gave, SC did nothing more than receive a file and log into a call. She took no action, no steps, no affirmative moments on her part to violate the code of conduct. And without more, she simply cannot be found in violation. As a general rule, the district and I agree on a lot of things, right? Our facts are not hard to understand and are largely not in dispute. We all agree that a 12th grade student named GS impermissibly accessed student records from the Fulton County server. GS has no doubt violated the student code of conduct. He was able to do so not because he hacked the system, as the district likes to say, but because the district failed to safeguard its own data. For
Right.
7 years.
Didn't this arise from some sort of middle school password?
That is exactly what happened, Your Honor.
Okay.
I would allege that if anybody violated IFGBA, it is the school district for failing to change their passwords on a regular and routine basis, as they are mandated to do. Right? It wasn't a sophisticated hack. It was he had access and he impermissibly, right, whether he had access or not, impermissibly accessed that data. He then shared a file that purported to be a discipline file with several students, including SC, via Discord group chat. Think of it as a group text, right? It was a message that arrived with an attachment. I don't know about Ms. Akins, but I spend my whole life looking at Excel files on my cell phone. I do not own a personal computer, and therefore I do not open my work laptop when I'm looking at things that people send me, and I look at them on my cell phone. My cell phone's big, that's why. She absolutely could have looked at that file on her phone. And importantly, as I outlined in my brief, nobody knows what this file is. GS identified that he found a file. GS identified that he sent a file. SC identified that she received a file. Every administrator who testified identified that they did not ever see the file. Whether it be from GS, whether it be from SC, whether it be on cell phones, whether it be on laptops, nobody, none of us have ever seen this file. We honestly have no idea what it is. GS could be making it all up. We just don't know. Right? There's no indication that SC opened this document on anything than her personal cell phone. We've had a lot of conversations about what SC's statement says. SC's statement is not anywhere near as clear as the district would have you believe. SC's statement does not say it was on my computer. SC's statement does not ever say the word maintained. Just SC's statement does not say that she put it there and she left it there for months.
Right.
What SC said.
It says what I know what it says. It says, yep. I don't know if it's still there, So I don't know if it's still on my
No,
district
no,
device.
let's be clear. What she says is, I opened it on my cell phone. I don't know if it's still accessible on my laptop. Accessible on, let's again go back to not 16-year-old terminology. I have a Gmail account. My Gmail account, much like Discord, is a web-based program. When I get an email from my Gmail account, again, because I live on my phone, I open it up on my phone. That's my cue dog. I open it up on my phone. When I open it up on my phone, if I were to log into my Gmail account on the work computer that I am engaging in this Zoom call on, I could log into Gmail and see if that document was still there. Accessible on is very different than on. I opened it on my cell phone, and therefore I don't know if it is still accessible on my laptop because I opened it on my cell phone. I don't know if you can get the Gmail account on my laptop or if the document still exists on my laptop because I opened it on my phone. That's what she says.
One thing, forgive me for interrupting, Ms. Waldman, but one thing that I was a little confused about is that there doesn't seem to be any dispute about things being sent or possibly received, but was this being sent in a Discord chat? I know that was the discussion that was had, but this is not like somebody sent an email to somebody, because do 16-year-olds even use email?
No.
They
It's
don't.
just like
Mine
that.
don't. So
it's much like that. Think of it. I actually don't use social media, but
that's
I
impressive,
understand.
Ms. Waldman.
I know I don't have an Instagram account, a Twitter account, a Facebook account, or even a LinkedIn. I have none of it. But my understanding, right? Think of it more like an Instagram private message.
Right.
That's being sent to a group of people at once. So no, they're using it. It's a Discord group chat.
Mm-hmm.
Is what the evidence demonstrated in SC's case. I can't speak to others.
Okay.
Is that is how she received the file, which again has an app on your phone, right? Much like Instagram or Facebook have an app on your phone, there's an app on her phone that's a Discord app that she opens up and looks at. So that's, and we have to take, again, the statement in the context of how it was written. It was written in the context of a conversation with an administrator, Assistant Principal Lundy. The district, during their opening and I think throughout their brief, made a number of mischaracterizations about the testimony. But when Ms. Lundy testified, and this is on page 213 of the record, Ms. Lundy specifically says, I don't know what else she did because this is consistent with what she told me, which is that she opened it on her phone. Right? Her conversation with Ms. Lundy was a conversation about district laptops where she was trying to answer a question, right, about laptops. Why are we, right? We're making a big deal about laptops because we don't know. Right? We don't know. Why don't we know? The district is saying, well, we don't know because we turned it over to the police. That was a choice. That was a choice made by the district. SC and her father came into the school willingly. They brought a cell phone and they brought a laptop and they said, have at it, search it all. They had SC open some things. They didn't take her phone. They could have. There was never an opposition to it. They took her laptop, and they could have brought IT in. In fact, we know that we do criminal investigations. We actually investigate before we turn things over, right? They could have. This was a school discipline process first that turned into possibly a criminal investigation, but there was nothing prohibiting them from actually doing the school discipline investigation first. They could have looked at her laptop. We'd have a very different hearing, maybe if they looked at our laptop and we'd know whether things were on it or not. But they didn't, and that was a choice. We are 6 months later, 8 months later, we are a long time later. We still don't know what was on the laptop because nobody has ever looked at the laptop. To this day, nobody has looked at the laptop. That was a choice. And let's remember that the burden was on the district to prove things. So let's look at, right, why this matters, right? Why this matters. The district, again, has made some conversations about she could have refuted it. Well, she didn't refute it because they didn't allege it at the hearing below. If I might screen share, hopefully without crashing my computer, because Zoom has not been friendly to me with screen sharing. I'm going to screen share the notice, right? This is what SC was given notice of. SC was given notice, right? And I'm going to go to their simplified version of it. Alleged acts. On or about 1/26/24, the administrative team at Fulton County FCS Innovation Academy was made aware of a student call that took place on or about 1/24. GS, YH, ES, AL, SC, and others joined and remained on the call. During this call, GS read aloud student discipline files containing personal information that were impermissibly accessed from the district systems. Right? Again, was on the call. She joined and remained. That's it. That's the allegation. SC received a copy of a file containing personal information sent by GS months before the student call. The file received by SC contained personal information that GS, again, not SC, GS, impermissibly accessed from the district systems. GS informed SC that he impermissibly accessed and downloaded the personal information contained in the file from the district systems. That's their allegation, right? The allegation is not confusing or hard. What's missing from the allegation? What's missing from the allegation is that she did so using her personal school district laptop. What's also missing from the testimony of the hearing, at the hearing, was that she used her personal cell phone, her district issued laptop. Nobody said it, and therefore there was no reason for SC to break her right to remain silent to refute a thing that was not actually alleged. Why didn't she refute it? Because they didn't say it. This has become an issue for the very first time at the state board level. Why? Because they realized their case was weak. They realized that the interpretation of the law, any interpretation of the law, does not allow viewed, received, listened to violate their code of conduct provisions. Which then goes to the district, again, has made a lot of noise about you have to defer to the findings of fact that are made by the hearing officer. I agree. I think that is an absolute true statement. But what Ms. Akins did is inferred findings of fact from the hearing officer because she heard the evidence and she must have found the following things. Well, we know what finding of fact the hearing officer made. If I may share one more time, the hearing officer made a very, I'm pushing my luck here, made a very explicit finding of fact. The finding of fact was clear. She violated the code of conduct, right, on 1/24 and a prior date by viewing confidential discipline records from the Fulton County District and not following the responsible use agreement. Viewing the records. That is the finding of fact. There's no finding of fact that she did so on her school issued laptop. There's no finding of fact that she downloaded the records. There's no finding of fact that she maintained the records. There is a finding of fact that she viewed a record. Viewing a record does not violate the code of conduct. Quite simply, Your Honor gets to interpret whether viewing a record, which is the finding of fact, violates the code of conduct. You owe no deference to the finding of law. You get to interpret the code of conduct, just like the state board did. The state board interpreted the finding of fact, which is she viewed a record. That's all we have in front of us, and found that it did not violate the code of conduct. It's that simple, Your Honor. For that reason, right, and I will go through the codes of conduct provisions as Your Honor has done with Ms. Akins, one by one, to identify why we don't believe that that is a violation, even with the district's interpretations of all the things. We don't think that it's a violation, but importantly, we have one finding of fact, view to record, and that is not enough. And so looking at, right, let's look at jurisdiction first, as Ms. Akins did. Jurisdiction, they are hanging their hat on jurisdiction being the use of the personal laptop. I think we have hit that nail down as hard as we can. I think we all know what her statement says, and that's it, right? Her statement is the only evidence. As a side note, I understand Ms. Akins' position that hearsay is admissible and all the reasons why hearsay is admissible. We had fully briefed below.
Certainly that would be an admission by SC. We're going to get down into the weeds of evidence.
Which is, and again, I think this is important as a distinction between where the world of criminal is and where the world of an administrative hearing, where hearsay is always admissible. Our evidence code draws a distinction between non-hearsay. There are certain things that are non-hearsay, and hearsay that is otherwise admissible, which is a statement of a party opponent. I don't think we need to make that decision today. I don't think it is essential at all to my argument, but I would like to preserve that as I need to preserve as we go forward.
Hang on, forgive me. Let me make sure that I heard you correctly.
Yeah.
My understanding is that 801D2 is that there are things that are not hearsay, which is a statement by a party opponent. And then there are exceptions, that things that are hearsay, but we allow them in because they fall into one of the exceptions. Did you say that a different way? I'm sorry.
No, yes, I think that is right. So D1 says an out-of-court statement shall not be hearsay.
Right.
If the declarant testifies it, right? So D1 calls things not hearsay.
Right.
D2 says they are exceptions to the hearsay rule, right? Which means that they shall not be excluded.
Okay.
And I understand that seems like a semantic moment, but again, code provisions say what they say, they mean what they mean. And why do we have a D1 and a D2 if we were calling them all non-hearsay?
Fair enough.
In a criminal matter, that doesn't really matter because it's either admissible or it's not admissible. But in this case, where it's all admissible, but then it all can't be utilized as the sole piece of evidence, it matters more. That is an argument we briefed fairly fully below. I will happily answer more questions about that. I think, right, again, I don't think it matters. I think even if SC's statement is in, SC's statement doesn't say what they say it says. SC's statement doesn't mean what they think it means. And there is no evidence that she actually utilized her school district laptop to, in any way, access these discipline files, right? She's not sure if they're accessible, right? She's not sure if she can get to them. And what we know from the record, and what we know from district policies, is that Discord is blocked on their school district laptops. So in all likelihood, it probably wasn't accessible on her school district issued laptop. But there's no, Ms. Lundy's testimony wasn't she used it. It was what she told me is she used it on her phone. And that's very consistent with what her statement says. And for that, right, we would argue there is no jurisdiction over SC because she did not utilize school district resources to access these documents, if she did even access them, right? As we understand how those things are. Moving on to the guilt. I can do these in any order you wish. As you rightly have identified, there are 3 code provisions at issue for SC. Those code provisions, 2 of them don't come with anything more than a short-term suspension. However, to the extent that we are here, I believe that it is appropriate to decide them such that her record can be cleared of misdoing and inappropriate behavior as we go through this process. I would like to dispose of those first and then get to the big one, but I'm happy to do those in the reverse order if you'd like.
No, go ahead.
So 18E1, right, defined as cell phone use, right? Your Honor's interpretation, right, is the correct one, which is, this is clearly about commands and compliance. It's interesting to compare 18E1 with 18I1, right? Because 18I1 says violating the district's responsible use agreement. 18E1 has a lot of words before it says in parentheses and also IFBGA. If what they meant was anytime you violate IFBGA, you have violated Code of Conduct provision 18E1, they sure did waste a lot of words, right? What they say is refusing to comply with reasonable directions or commands of school staff regarding the reasonable use of the policy. Not just put your cell phone away, which is the easiest example, but put your cell phone away. Don't log into things you're not allowed to log into, right? Don't try and get to Discord. All of the other ways you use it, while you are using it inside a classroom, when a teacher tells you stop, you should stop. That's the only reasonable interpretation of 18E1. Yes, there's a lot of stuff in IFBGA, but if they wanted to include all of IFBGA, then why all of the other words? It's just not conceivable. What they meant was violating IFBGA. It's undisputed that SC was given no commands. She was given no directions. In fact, nobody knew she did any of it because it happened outside of school on her personal cell phone when there were no staff, teachers, administrators, anyone anywhere near her. And therefore, right, she did not violate 18E1. So let's move to 18I1, right? Violating the district's responsible use agreement. The state has made a lot of, or the district, I apologize, has made a lot of assertions that the hearing officer just simply didn't read the rule. I think that's quite offensive to the hearing officer. She, like Your Honor, has a very specific job to do. That job, we should assume, she took seriously. She did identify that she actually looked at IFGBA. She looked at the responsible use agreement, and she came to a different determination as to its applicability in the law. So 18I1 just says violate the district's responsible use agreement, operating guideline, IFBGA in any other way. It's important to go back, right, to school technology resources, which is the very definition that starts the Rule 18 violations. And it does say includes, but it not limited to, but it is a very instructive list of things that they are talking about. Electronic media systems devices such as computers, networks, websites, the associated hardware, software programs used for purposes, right? If you look at IFGBA and you look at what they're talking about, they have a really long list of things about their enterprise network, right? Again, what this code of conduct is looking at is whether you're appropriately logging into the system and utilizing the things that are on the system appropriately. Yes, it talks about the word data, but it talks about the word data in the context of the enterprise network system houses data. And therefore, breaching the enterprise network system that houses data is inappropriate. Again, what GS did. It's not about every time you have a piece of data. Let's take our examples again to things that happen in the real world. Let's pretend that the district, the school, and staff member accidentally sent you a file of somebody's student discipline records. Happens all the time. Happens all the time as lawyers. We accidentally send the wrong party a file and we say, oops, our bad. When I open that file that was accidentally sent to me, I have not violated the code of conduct. It just can't be that broad. It is not that broad, right? What we are talking about is intentional conduct of breaching a network system, utilizing and misusing, using being the operative and key word, using the information inappropriately. Let's go back to our allegations and our proof with respect to SC. Our allegations and our proof are that she viewed a file that she was sent and that she was on a call where things were talked about. That's it. That's what she is accused of doing. She didn't manipulate the data. She didn't share the data. She didn't talk about the data. She certainly didn't taunt another child about the data. She did none of those things. She acknowledged that she got a file and she viewed it.
And so, Ms. Waldman, your position is that section X on page 56 and sub 4, which I think is what the state is relying, or the school board district is relying on, that if the finding of fact was that SC viewed data belonging to the district, your position is that that rule 56 on to 57 only applies, quote, when accessing their account. And she was not accessing her account at the time and was not on her device.
That is correct. That is, I think that is the only reasonable read of those provisions. I'll note, we are all remarkably intelligent people. I'll speak for myself. We are parsing some language and trying to figure out what this code of conduct means. SC did not go to law school. If we are having this much trouble figuring out what this code of conduct provision means, and I recognize that we did not make this below, but boy, is that impermissibly vague, right? We have to interpret it in a way such that SC could have known and been on notice of what she is accused of violating.
Well, I mean, in fairness, she may not have gone to law school, but these three
She is
students
smart.
probably know way more about how this technology works than any of us all put together. So
That I don't doubt that to be true. But statutory interpretation is a very different skill set that is not taught at Innovation Academy. And where, like, again, reasonable minds are clearly disagreeing. I don't think there's a reasonable I don't think there's any way to interpret this statute otherwise, quite frankly. But to the extent that somehow the district does, that's concerning because we're struggling, right? With that, let's turn to 18E1. 18B3.
3.
The big one, right? It permits essentially 3 buckets of things, right? 1, copying computer programs, software, or other technology provided by the district for personal use. It appears to me that is not being alleged by the district. I have not seen it in their briefs. They did not respond otherwise when I said it's not being alleged. I believe that is not at issue here. She has not copied programs, software from the district. So we get to 2 and 3. Just to download unauthorized files, right? We have spent a lot of words on what the word download means. Again, lots of confusion in our record about what the word download means. Whether you download something when you view it, I would assert that, right? Again, maybe, but certainly not intentionally. And let's focus on intent. Important to note again that our hearing officer's decision identified the word viewing, not downloading. That is the finding of fact that we are bound by. Viewing, not downloading. We certainly haven't presented any evidence that she viewed it or downloaded it on her school laptop, right? Again, still accessible on, we're not real sure what that means, but what we know is she said both at the front end and at the back end of her statement that she accessed it on her cell phone, right? She was very careful to say that that's where I did it. That's how I did it. That's how I looked at it. Which then brings us again to the question of whether this piece of information is enough, right? So let's go back to number 3, right? So she didn't download an unauthorized file, certainly not on her school issued device that would bring her within the jurisdiction, which goes to 3, school technology resources for personal gain or private business enterprise. I think Your Honor dispatched this pretty quickly as it relates to SC because it's pretty far out reconceptualization of the record to identify that she was using this for gain. There was one administrator who testified over objection where he was told to only talk about personal knowledge and then kept going anyway, that he understood, to use your teenager's words, there was beef among some students. But there's no indication in any of the record that SC herself had beef with any of these students, just that it was perhaps a friend group. There's no indication, and Mr. Q, I'm not going to say his name right, so I'm going to stick with Mr. Q, specifically testified that no, SC did not use the words, I would like that file to be sent to me. No other teacher indicated that she asked for the file. The evidence demonstrates, right? All the evidence can show is that unsolicited, a file appeared in her Discord group chat. Then, right, the districts like to say a lot of things about she had it for 2 months. Well, in those 2 months, no word got back to an administrator that SC was bullying another child. No word got back to an administrator that she shared it with any other student. In fact, again, the testimony was that they had no knowledge that she had done any such thing. No testimony came out that she did anything with this document. As far as the record is concerned, she did what I would have done when I receive a file I'm not supposed to get. She opened it. She said, not about me. She closed it and she moved on with her life. That's what the record can be interpreted as saying, and is in fact the only fair interpretation of what happened. She gained nothing. How could she have gained by not using a file that she has? Same with the voice call where she was muted, right? We've heard a lot of testimony in the record below about how Discord works, where there's whiteboards and there's games and there's things that happen on the side and people half listen. And it's kind of, I equated this again, because I'm old, to like the old party lines that we used to have when I was in middle school, when we'd all get on the phone together and we'd start listening. And right, you didn't have to pay attention or know what was happening. There was just a place to hang out, right? It's like the coffee shop online. That there's stuff happening around you, but just because it happens around you doesn't mean you're part of it. SC did nothing, right? SC's passive conduct is all that we have here. Our courts have told us that intent is an essential element that must be read into each and every code of conduct provision. The most important case on this cited in my brief is Goldwire v. Clark. That's at 234 Georgia App 579, which tells us that without evidence to satisfy an element of active conduct, a violation of the rule is not shown. They have shown nothing active by SC.
I'm sorry, Ms. Waldman, 234 Georgia App.
579.
Thank you.
And it's at page 585.
Thank you.
There's similarly, again, cited in my brief, a State Board of Ed decision, right? So it's not just the Court of Appeals saying it, but the State Board has also sent it. That's CW v. DeKalb County Board of Ed. It's case number 200-15, finding that intent is material, even where we're talking about possession of a firearm on school property, right? It's not, these are not strict liability offenses. These are offenses where you must intend to violate the code of conduct. The state board was absolutely correct that SC intended to do nothing. Importantly, the district has proven nothing, whether you take her, whether you assume it's a discipline file, whether you assume her statement comes in as non-hearsay, whether you take every piece of evidence that was there, and there is zero affirmative actions other than a viewed file by SC. And a viewed file that we don't know she knew what she was viewing before she clicked on it. Right? She received a file, she clicked on it, she did nothing. That simply is not enough to find her to have violated the Fulton County School District's code of conduct. I will touch briefly on discipline because Your Honor asked those questions. The only discipline that could get her where we are today is that tier 3. We have made extensive arguments about the unconstitutionality of the tier 3 escalation as it applied to SC. I do believe, as I wrote in my brief, that the appropriate solution, if you rule against us, is that it gets remanded to the State Board of Ed to determine discipline. I'm happy to have you decide it, but I am not sure. I think remand for the issue that was undecided because the state board punted on it because they said they didn't have to reach it. I don't think there's a decision from the state board for Your Honor to review. I do think, however, you get to talk about the constitutionality because that's going to be a de novo decision no matter what. Everything else is probably a factual decision that the state board has to rule on first. And then the last point I will make with respect to discipline is by harping a lot on sovereign immunity, the school district appears to be telling us all that they don't care if they lose. Because if they lose, they have no intention of putting SC back to her rightful place at Innovation Academy. They're doing that by talking about sovereign immunity. Sovereign immunity is explicitly waived as a constitutional provision, right? If they file a lawsuit. The school district initiated its school disciplinary proceeding against SC. They didn't just initiate this lawsuit here today. They started this whole proceeding. They don't get to start a proceeding, initiate a lawsuit, and then say, but the consequences don't matter. Like, we can do whatever we want and we never face consequences, even if we are initiating her. They started it. They have waived sovereign immunity by filing this proceeding against SC, starting with the very day they did so down at the local level. Secondly, right, we can't have what is a purely Pyrrhic victory, right? If SC wins and her discipline is overturned, the only possible outcome as a matter of procedural due process is to revert her to Innovation Academy. That's where if they did not illegally discipline her, they could not just kick her out. They have a contract with her that she signed when she got there. Yes, it says she'll follow the code of conduct. But if Your Honor determines that she followed the code of conduct such that procedural due process was appropriately initiated by this and she wins, then we're back to she didn't violate the code of conduct and they don't just get to kick her out of Innovation Academy. They don't get to say we can kick her out of Innovation Academy even if, like, let's pretend they never filed a due process complaint. They never filed it's called district due process, a tribunal hearing, a 754 hearing. If they never filed that, they didn't get to say, you know what, we think you violated this. We're kicking you out of Innovation Academy today. That would be a procedural due process violation. And I believe Ms. Akins and Mr. Ryan would agree with that, right? We don't get to just kick you out of school.
But what about Ms. Akins' point that, you know, the school didn't do that, right? The school board did that, and the school board has almost unfettered discretion to fashion appropriate remedies in terms of, you know, when there's been a violation.
If there's been a violation. What I'm saying is if we win, the district is trying to tell you they're not returning her anyway. If we win, that's where I'm at. I'm not saying if we lose. If we lose, then I have to deal with punishment with the school board, right? With the state board. But if we win, if Your Honor finds that they have violated 0 code of conduct provisions, which is why I think that is important, right? If Your Honor agrees with the state board and finds that the state board has made a decision that is not clearly erroneous or an abuse of discretion, and we win, they don't get to kick her out of Innovation Academy. They are telling you by making this sovereign immunity argument that that is exactly what they intend to do today. And that cannot stand as a matter of procedural due process, right? That they don't get to just do that because they're hiding behind sovereign immunity. They couldn't do that on January 26th without going through the due process, right? They couldn't do that without having a hearing and proving that she violated things, and they can't do that now. She must be returned to her pre-discipline status quo, which is at Innovation Academy.
Thank you, Ms. Waldman.
Thank you.
Okay. Mr. Adams, you represent ES, correct?
Thank you, Your Honor. Yes, I represent ES. And I want to make this as efficient for the court as I can, because I think the situation with ES in many ways is very similar to that of SC. And I will point out and happy to discuss further issues that differ. But the big picture is that ES was in a similar situation in that she was on this same January 24th Discord call, and she was alleged to have received some kind of file in the fall before that. One important distinction is that with respect to that supposed earlier receipt of the file, we don't have the same evidence as there is with SC. What we have as part of our record is SC's own statement that SC and ES and GS were all on some kind of chat through Discord in the fall, and SC says that's when GS sent me, being SC, this file. Now, we don't know as to ES, even assuming that she received that same file, we don't know that she was ever aware of it. We don't know that she opened it. We don't have this issue of what device did she open it on, because there's nothing in the record about her actually receiving this, being aware of it, except for the fact she was on the same call. So perhaps she received it, but no awareness of that, as far as we know. Certainly no record.
Hang on.
Sorry,
So, but what about the actions that are in the record that she took after there was apparent knowledge that the administration was aware of some issue? Can't her post, January 24th actions, wouldn't the school board or the hearing officer be authorized to infer that those actions implied that she had it and knew she had it at some point?
Yes, Your Honor. I would say that's correct if there were finding of facts to that extent. And I think probably the best thing to do is to go through all that, because I certainly do intend to get to the aftermath. Okay. I just wanted to frame this as, for the most part, the basic big picture facts are very similar to SC's, with, I would say, the subtraction of not the same evidence as to was she even aware she received it in the fall, and then yes, the aftermath, her situation is different, and I'm happy to discuss that.
Okay.
I do want to point out, though, while we're on that one issue and sort of the similarities, Ms. Waldman made a very important point about what were the actual findings of fact, because that is what would get this potentially, to the extent that we're still in the pre-SCAPA standard of review, that would get this any evidence deference, if you want to call it, or this clear error deference, the factual findings, right? not any of these interpretations of the rule, issues of law, which would be de novo. And so when it comes to ES, those findings of fact are a part of the supplemental record that was provided that Ms. Aiken referred to earlier. And I can give you the exact page number if it's helpful. Yes. That was page 18 of the supplemental.
Thank you.
And so with regard to ES, and I don't know if Ms. Waldman was referring to the same analogous screen that or page that I'm referring to, but if you look at subsection A, it's explicit that this is findings of fact and rules violated, and then it goes on further to describe them. And so as to ES, it says, by violating the district responsible use agreement. Well, that's not a finding of fact. That's a conclusion of law. The next part appears to say, stating that she had unauthorized documents on her device. Now, again, similar to situation to SC, had unauthorized documents on her device. So nothing about downloading, nothing about accessing, nothing about knowledge, and her device, nothing as to which device we're talking about. Okay, so at most, these are the findings of fact that for which that the any evidence standard might apply. And I would submit to you that the rest of that is also some combination of conclusions of law and also just not establishing. And I'll get to the aftermath when we get to this bit about encouraging deletions and that kind of thing. So I want to give a little bit of context to the facts surrounding the ES situation. And so, like the other students, ES was an excellent student, had this high GPA that you referenced. But there's two things that are important about ES because they give some. They're important for the context and the picture that the district has tried to paint surrounding some of her Discord messages and all that. The first, which is in the record, is that she has an extreme sense of empathy. She won an award last year at Innovation Academy because of how concerned she is for other students, right? And that really comes out here. And we'll get to that in a moment. And the second is she has well-documented anxiety. And one of the supplemental materials that was provided in S3 was a therapist letter talking about how one of the manifestations of her anxiety is that she has this sense of guilt for any interaction that she perceives as wrong. And so you combine these things, she really cares about other students and she blames herself when other students are being wrongly treated, really provides some important context for the aftermath in particular, which I want to get to, because that is what may differ from the SC situation. And so when it comes to the January 24th call, so I don't think it's disputed. This was a call over discourse, which, as Ms. Waldman pointed out, is not available on FCS devices. And that's also in ES's own statement, which is on 595. Where she talks about the purpose of this call. It was not to discuss student records. This is something that GS just brought up midway through the call. Nobody was expecting. When he started doing it, ES says she discouraged him and she told GS that his actions were illegal. And now keep in mind, this is a sophomore telling this to a senior. She also notes that GS did not send any records. So we have all kinds of references to these briefs about records being sent over Discord during that January 24th call. No, there were no records sent over Discord in that call. There's no evidence of it. And although it was not part of our record, I believe that GS says that himself in his own statement, which is part of the other records. He described the student records orally. So that's January 24th, which brings us to January 25th. And so ES is messaging on that day, the next day, with her friend Kay, and he goes by the screen name on Discord of, I'm probably going to botch it, but it's Thor the Gamer God. And this whole exchange is Exhibit A7 to the district's, to their record in ES's case. And it's R598 to 615. It's also A8, which starts at 618 in ES's record. And this exchange, I think, is pretty important because it's been mischaracterized pretty blatantly by the district. And it starts off, I think it's more visible on A8 actually at the very beginning of it, but it starts off by ES mentioning that GS did something illegal last night. She later goes on to describe it, which is hacking into the FCS records, which was her understanding. And she talks about how she's feeling responsible for letting it slide. Keep in mind, this is a student who tends to blame herself for situations, rightly or wrongly. It's not clear what she thinks she should have done any differently. If it was, shut down the call because she's the moderator, or call the police immediately on this senior who's disclosing this information. But she's clearly bothered by what happened. And I think it's notable that she's having this reaction right now on January 25th, the day after the call. Given what we know about the type of person she is, none of this happened back in the fall when she supposedly got these records, which further reinforces the fact that she wasn't aware of anything being shared in the fall. Okay, this seems to be her first time confronting this whole situation. So she's having this back and forth with Kay, and Kay tells ES that the school is basically investigating the wrong person. There seems to be something going on at the school on January 25th. Somebody's getting pulled out of class. Let's call him G, not to be confused with GS, because it's a different person.
Mr. Adams, forgive me for interrupting. I do not in any way mean to be dismissive of struggles that ES may have that may have informed her choices. But that feels like a lot of context that may or may not be taken into account when the decision makers, should there have been discipline, were making decisions about discipline. But I think it would be, and also I've read these emails, right? I'm sorry, my children are laughing at me somewhere for referring to them as emails and sounding 1,000 years old. I've read these messages back and forth. And so, and I took some time to try and figure out who was who to the extent people were identified. And so I feel like I have a good understanding of the communications that were made and what they say. Now, what was intended or what motivated those things, I'm not sure is immediately relevant to our task here right now.
Yep.
Go ahead.
Understood, Your Honor, and I appreciate you doing that. The only reason I'm bringing it up is because of how it's been mischaracterized by the district. But I'm glad that it sounds like you have a handle on that. So let me fast forward a little bit then. So, Kay is, they're talking about this other student being reprimanded, and ES is concerned that he's being falsely convicted. And so she goes through this blaming of herself, and this is at 599. And this part, I think, is telling as to her conduct, because she says again, I allowed it to happen. And Kay says, did you do any of the actual hacking? And she says, no. Kay says, that is not your fault. ES says, and this is the important part in particular on 599, I don't have access to any of their records, but G was falsely convicted. So this is her concern about G. But in discussing that, she says, I don't have access to any of their records. So that's important. So Kay goes on to give more details of how the wrong student was being investigated. And ES comments, oh, that's GS, that's the person. And so then Kay encourages ES to provide the name of this actual hacker, which is GS. And so she does so. And he continues to talk her down about how this is not your fault. And, this is what someone else did. And then meanwhile, while he's having this chat, he's having a separate chat with a friend whose dad is in the district's IT department. And he provides him the name of this other student, GS, who actually accessed the system. And so it's this truthful cooperation between K and ES, who actually, it appears, lead the district to identify the correct person, which is GS. And so I would suggest that all of this aftermath on the 25th is students doing what we hope they would do. They're concerned the wrong person doesn't get blamed for this. They identify the right person, and it's Kay who brings that to the administration's attention. And it's a good thing he did, because the right person was reprimanded.
Right, but how do you reconcile the statements by ES in the texts, right? That, oh, I don't have any of the records, with Mr. Q's, I don't know if it's Mr. or Ms., but Mr. Q's statement that that administrator personally observed ES trying to log into their system, and when asked what they were doing, specifically stated, I have records that GS got and they're stored on my computer.
Yeah, well, thank you, Your Honor. Let's talk about what Q actually says that ES said. Okay, so this is page 19 to 20 of the transcript, and I believe it's page 251 of the record, 250 to 251. And what Mr. Qureshi says that ES says was, I think I have files on this computer based off of the whole situation.
Okay, just to be clear, I'm looking at page 597, and it says, this is Mr. Q saying, I spoke with ES's father, and when I walked in, and then it says, I asked ES to please give her computer to me, and she became nervous and told me that she received files from GS that were stored on her computer.
And I'm sorry, Your Honor, what page did you say that's on?
597.
Okay. Oh, okay. Yes, Your Honor. So you're talking about Mr. Qureshi's written statement.
Yes.
Okay, yes. So I would submit a couple things, Your Honor. First of all, the district, most of the time when they cite to this, they cite the testimony from the actual hearing.
Okay.
And I think, as opposed to the written statement, and I think they do that for good reason, which is that's at least Mr. Qureshi testifying at the hearing as to what ES told her. So we've got all these issues of, is it an admission? Is it, that kind of thing. This is in a different category, this written statement, because this is not even an in-court statement. And I would submit to you that this is different. I don't think that this qualifies as a statement against interest in the same way, because it is this written statement, this additional element of hearsay in this. But nevertheless, what he says was, told me she had received files from GS that were stored on her computer. Even if we take this at its word, received files that were on her computer. That's it. I mean, so I mean, we don't see that she downloaded it. We don't see that she had any idea of what these were all about. We don't know any of the context. We just know, again, we don't know, but if we assume that she had files on her computer, that doesn't meet any of the criteria for the rule, which is this downloading and all the other elements of the rule.
Except, I mean, I guess what I'm going to, and if Mr. Q's statement gets there, in terms of what was before the hearing officer, whether it was what he said during his testimony about ES or whether it was in the statement that was in the file, if ES acknowledged that that information was on her computer, that implies a level of knowledge and an attachment to the school device that perhaps, at least according to Ms. Waldman, is missing in the relative to SC. Does it not?
I don't think it's really, I disagree, Your Honor. So, he's saying that she received files from GS that were stored on her computer. So we're still just talking about what she may have received, right? So it's not talking about what she did. It's not talking about that she even opened them. It's not talking about she downloaded them. It's not talking about she accessed them. She's speculating as to what might have possibly ended up on her school device. That's it. Even if it did end up on her school device, that doesn't get them the jurisdiction or the rules violation, because the student has to actively do something for it to be a violation, for there to be jurisdiction. I mean,
Well,
if you look,
I don't want to get down too far into technological weeds that I don't understand and I don't necessarily think are part of the record. But if in fact, the presence, if in fact what's been represented, and I don't know if it is in the record or not, that student devices can't access Discord, then the presence of that data on her school device would imply some knowledge or active accessing or downloading, for lack of a better way to put it, than perhaps other students. And that's what I'm trying to understand.
well, I mean, Your Honor, I will acknowledge it's hard to know what her speculation was here. And that's sort of exactly the problem, is that at this point, she makes some comment. If we look at the transcript, there might be something on this laptop related to this whole situation. What did she mean with that speculation? Well, if we really want to know, I mean, first of all, we would examine the device, which never happened. Second of all, we would ask a follow-up question. What do you mean? What are the files on your computer that might be on your computer? Let's look at your computer, or tell us more about that, or which files. We're left to speculate with all of this about what these files are, and why she thinks that might have happened. I mean, these students they have lived their entire life in the digital age, right? And so unlike me, at least, they have this awareness that something, you open it on one device, as Ms. Waldman referred to, your Gmail account, and it might still be on this other device, or you might be able to find it on their other device. I mean, sure, it's conceivable that if she went on there, maybe she's able to locate it, but it doesn't mean that she put it there. It doesn't mean that she even knows what it is. It doesn't mean that she opened it. It doesn't mean she downloaded it. It doesn't mean any of those things. And we shouldn't have to speculate as to what she meant by this. So, Your Honor, I guess I want to, if it's okay with you, Your Honor, I wanted to move on a little bit then to a little bit more about the removal of references to confidential information from the Discord, because the district spends a lot of time focusing on that in their briefs. And so I think
forgive me for interrupting. Sorry, forgive me for interrupting, but let me make it easier for you. Is your argument that there's not, that regardless of how they came to exist, right, that the destruction of that information, the deletion of that information, doesn't constitute any sort of violation of the code of conduct?
That is correct, Your Honor. I would agree with that as a matter of interpreting the code of conduct.
Okay.
Now, I would also say that I disagree with the way the district characterizes this whole situation happening. So GS, in ES's statement on 595, GS says, he asks her to delete information. She says, she's feeling overwhelmed, and she basically puts him off, but she bans him from this group, so he can't do any more harm on it, post anything on it. And she relinquishes moderator control to YH. And this is all in our brief in the record sites. So she does that. And I would analogize it to, you know, a situation to date myself, but if you are on a Facebook page, somebody posts something you don't like, I mean, what are you gonna do? You're gonna get rid of it. You're gonna tell the person to get rid of it. You're gonna, you know, allow them to get rid of it. You're not under an obligation to keep it there on your private social media account, to keep something there that you didn't want there in the first place. And yes, Your Honor, that's a long way of saying that is not a rules violation.
So, but what about Rule 22? Is your response 22A2, right? Is your, because ES was found responsible for was found to have violated that rule, largely based on the actions taken afterward, for encouraging deletion and sort of, as I said earlier, the cover up. How do you, I mean, there does seem to be some discussion, whether you characterize it as encouragement or whatever, but there does seem to be some discussion about getting rid of the evidence. Is there, I mean, is your position simply that if there's not a violation in the first, if deleting it isn't a violation, then encouraging people to delete it can't itself be a violation?
Well, I think it's correct, Your Honor, that the district has not cited what the rule says. You have to incite, urge, encourage, advise, or counsel other students to violate a rule of the code of conduct.
Right.
And the district has not said what that rule, that code of conduct is, by removing messages from this private Discord. That does not violate a rule of the code of conduct. So that is correct. I would also point out that, you know, there's some irony here in that the rule talks about encouraging misconduct, and it's undisputed that when this call happened, where there was the rule violation by GS, she discouraged him, right? So we sort of have the opposite. When it does come to the rule, the code of conduct itself, it's not encouraging, it's discouraging. So that's what I'd say about that one. I will point out that there's also just in the district's brief quite a bit of other sort of gratuitous commentary about how she's conspiring other students to blame on someone else and save herself and her other friends. I mean, as I pointed out before, she was the one who was concerned that the wrong person was being blamed, and she helped to solve that issue. So, Your Honor, I'm glad you brought up 22, since that was unique to her. The other charge that was unique to her is 18C Roman numeral 3, the threat, damage to property using technology. And so I want to address that for a moment, because unless you have any questions, I'm willing to essentially incorporate the arguments of Ms. Walden on the other rules as well as my briefs.
Okay.
So 18C Roman numeral 3 really requires two things. It's attempting to threaten to or damage, destroy, vandalize, or steal private property on school property. Secondly, while using school technology resources on or off school grounds. Again, there's no evidence that ES damaged, destroyed, vandalized, or stole any property. And there's also no evidence that she did it while using school technology resources, which, as we've talked about, is a defined phrase. So what the district says is that she stole property by downloading and maintaining it. Again, we don't have a finding of fact as to downloading and maintaining it on her district issued laptop. Certainly not over the course of several months. And then we also, and what we do have there, what the district relies on, I think it's important to point out, is all this administrator testimony. It's one thing for Mr. Qureshi, who was present for some of the events in question, as you pointed out, walking with ES back to the classroom. It's one thing for him to testify as to his conversation with her. It's quite another for Assistant Principal Lundy, who is prosecuting the case, was not present for any of these events, and is pooling together information from various sources in her mind with multiple layers of hearsay to then say what she thinks happened. And that's what their evidence, supposed evidence here is. If you look at page 307 of the record, which is what they cite for this idea that she was downloading and maintaining this information. But I would say that even if what she says is accurate, it doesn't show that ES stole school property, as the district says. At most, again, she's receiving school property, which there's no evidence she was aware of having occurred. And again, there's also no evidence that ES knowingly maintained these stolen records on her Discord for a few days or hours, as the district says, because again, records were not transferred during the January 24th call. They were described orally by GS. Your Honor,
So
I'm happy to answer any other questions you have, or I'm happy to also allow YH her chance to respond, her counsel.
thank you. And I appreciate that. I do have one question though, before I hand it over to YH's counsel, and that is on the issue of 18C3, right? So if, setting aside for a moment whether the school data, whether that, whatever that Excel spreadsheet may or may not have been, was data that belonged to the school, or if it was, it seems like that information was school property. And so would 18C3 not get the school to the destruction of the data? Granted, no one wanted them to have it in the first place, but the destruction of it, considering that it was school property, would that not, if in fact under the facts below were that ES destroyed or allowed or counseled for the destruction of that information, why would that not be a violation of 18C3?
Well, I think first of all, that there's no evidence that's what happened. So I think it's important to distinguish between the January 24th call, where GS is describing records. He's not actually sharing records. He's talking about them. And so the state board pointed out, I think it's on page 14 of the record, and it's true, there were no records shared on that January 24th call. So all this noise from the district about messages being deleted by various people, they're not the records being deleted, because the records were never transferred during that call. So that's as to January 24th. Now, as to the earlier, supposed ES supposedly being sent something earlier, we don't have any evidence of her doing anything to destroy that, because we don't have any evidence that she even knew she got it. So I don't see how. So no, Your Honor, I don't see how we possibly get there. It's deleting messages on your private chat, however that happened, does not get you to destroying school property, because it wasn't school property. It was their messages.
Thank you, Mr. Adams. As you mentioned a moment ago, I am now going to take this opportunity to call on Ms. Kirshner, if that's okay.
Yes, Your Honor.
Yes. Thank you.
I apologize for interrupting. Can we take a quick 5 to 10 minute break?
Sure. Before I hear from this, I can get more coffee. Okay, so it's 11:36. Why don't we try and be back at around 11:45-ish, and we'll go from there. Thank you.
Thank you so much.
Mr. Adams, just so you know, you're not muted if you
Thank-
intended to be.
Thank you, Your Honor.
Ms. Kirschner, can you tell me what firm you're with, please?
I'm a volunteer attorney with Atlanta Legal Aid.
Thank you.
Thank you.
Okay. Are we ready to go back on? See, we have Ms. Akins and Mr. Bryan, and we have Ms. Kirschner and our court reporter. So Ms. Kirschner, if you want to go ahead on behalf of YH.
Thank you, Your Honor. Yes, I represent YH, and for efficiency, I'd also like to incorporate the arguments of my colleagues, Ms. Waldman, Mr. Adams, to the extent that they are the same as YH's, and then I'll try to focus on the differences in our case and record. Briefly, as you know, on the night of the 24th, there were many students on this call, on this Discord call. All were students at Innovation Academy. Not all of them are part of the case. YH was actually doing a whiteboard activity with a friend for most of the call. And he was sort of in and out of what GS was talking about on the voice call part of the Discord. And he did hear at some point that GS was talking about student behavior records. He heard him brag that he had used a district login and password that he had obtained in middle school, and he verbally talked about some of the records. YH did not ask for or receive any records from himself or other students, and only overheard, like I said, some of what GS was saying. And then the next day, January 25th, in the evening, GS asked YH to delete some things from Discord from the day earlier. YH agreed because he thought that if there was anything about other students, he wouldn't want it to be accessible to anyone going forward. But when YH got the moderator permission, he went on Discord, but he didn't find anything relevant. He looked through all the messages. He didn't see anything with files. He didn't see anything talking about any of the other students or behavior records. And so while he was on, he just deleted some other messages that were not relevant to the student records, cleaned up the account, and basically just did normal admin stuff, which is, I guess, I'm not into Discord myself, but normal practice on Discord, according to his witness, who he had kind of extensively explained Discord to the hearing officer initially. And he was upfront about all of this in his statement, in his written statement. So the district is trying to argue that YH knew about the school's investigation when he deleted the messages from Discord. However, YH was not aware of any investigation until January 26th, when the administration began investigating the January 24th call. They brought in several students, including YH, who willingly complied and made his written statement. And then the school created what the administrator, Mr. Karishi, called his investigation summary, or anecdotal. And this included information that he had allegedly collected from all the students' statements, things allegedly said at student and parent meetings, and his own speculation sort of about what happened and the motives for what happened, as well as screenshots from one student's cell phone. No one, as you know, accessed the actual Discord server for firsthand information from its audit log, including whether anything was deleted by anyone else prior to YH's deletions. While YH turned in his district-issued laptop, there's no evidence that it was ever searched, and even if it was, nothing would have been found. He also willingly provided his personal cell phone, and they held on to that for several hours. But again, there's no evidence that it was searched. And again, even if they had, they wouldn't have found anything. They gave it back to him just later that day. And part of the problem in this case is that each student only knows their part of the case and only knew their part of the case when they went to the discipline hearing. And so their perspectives are all different, but the school, and, you know, through Mr. Karishi's anecdotal investigation summary, had actually compiled a full view of what they thought had happened. And the district, you know, presented different witnesses who were testifying to what they said happened, but really they had also refreshed their memory by reading Mr. Karishi's anecdotal statement. And in the YH's case, the hearing spanned about 6 weeks. There was 3 different hearing dates. Initially, there was not an interpreter. His family speaks Chinese. Then the interpreter was hired, but only for 3 hours. And then basically the hearing didn't take place or finalize until mid-March. And at which point, several of the people who testified said that the last time they'd looked at anything was at least 2 weeks earlier. And so basically, YH objected to several things at the hearing that were said that other witnesses, administrators from the school said that he had said in these alleged closed meetings. He objected to these things. They are not in his statement. And when we started hearing over the course of these appeals, what had happened in other cases, it appears that some of those are things that got brought in and twisted from other people's statements. So there's no official record from any of those meetings with the students, and there's simply no evidence that YH actually had student records on the January 24th call or at any other time. He's actually only charged with January 24th through the 26th. He's not charged with anything prior. And he actually didn't have anything prior, even though GS's statement says that he was sent something. YH does not recall ever receiving anything or opening, saving any of that. And the district says that they didn't do any investigation of the laptops because they turned them over to law enforcement. However, this wasn't instantaneously done on January 26th, and they could have pulled up actual information while the students were sitting there, if there was any, the day of the investigation, but they chose not to. So basically, the key differences that I want to highlight between YH's case and the other two are that, one, YH admits readily to deleting messages from Discord the day after the Discord call, but the day before the administration began an investigation to his knowledge. Although the messages were not related to student records and did not contain any student disciplinary files. Second, that there is no evidence that he ever requested, viewed, received, opened, downloaded, used, copied, saved, shared, or deleted, or anything he was accused of related to these student files that were supposedly pulled off the, I guess, district server by GS through this login and password that he had, whether on the Discord call or previously. And like I said, he's only charged with things that are occurring between January 24th and 26th. He's charged with 3, actually he was charged with 4, but 22A2, the encouraging misconduct, was dropped. But the other 3 he was charged with were the unauthorized copy of computer software that everybody's been talking about, 18B3, and then the 2 that sort of are ones we've been talking about also, but kind of questionable, 18C1, cell phone, electronic devices, recording devices. That's the one regarding not responding to teacher commands. And then 18I, violating the district responsible use agreement. Both of those latter 2, as you know, are only tier 1. And so they would only have been subject to a few days of out of school suspension. But by charging that 18B3, the school elevated or escalated to tier 4, which, as Ms. Waldman mentioned, we have challenged as being unconstitutional, and that was not part of the decision from the state board. They left punishment undecided because they found that there wasn't a violation. So they just didn't go into those details. But the other 2, if we got rid of that one and are unable, as we are here, unable to find that he copied, downloaded, or used any of the district's school technology resources, then that only leaves us with tier 1 charges, which wouldn't have been able to be long-term suspended or expelled.
Ms. Kirshner?
Yes.
I'm not sure it's dispositive of the outcome, but one of the things I was a little confused about with YH is that YH was a senior.
Yes.
And this happened in January of 2024.
Correct.
So one of the things I was confused about was what he was essentially long-term suspended for the remainder of his senior year. And am I correct that he's now enrolled at his local school to repeat his senior year?
Essentially, what happened was that he was initially expelled The disciplinary hearing officer reduced it to long-term suspension, but that
Right.
didn't actually change much for him because the expulsion would have been through December. It would have missed graduation. And because he was long-term suspended, it still went through May, so he still missed graduation. He was also allowed to go to
Well,
peak,
hang
yeah,
on.
sorry.
Let me ask you this. And that was actually where I was going is
Okay.
could he not, I understand he wouldn't have gotten the diploma that he wanted with all the AP credits and everything, but could he not have gone to peak and then graduated on time in the class of 24
So
as
he
his plan had been?
I don't know how this would have come into the record, but he did contact Peak, and Peak said that it was past the time that he would have been able to enroll in the online versions of the courses that he was taking, and that
Yeah,
the
that's
course.
at least in the briefing. I don't know if it's in the record, but
Okay. So then the other classes that he could have taken, he already had credits for, so he couldn't have taken them. They were already credits he had. So there wasn't anything available to fill those slots that would have gotten him to the point of graduation.
Okay.
If that makes sense. And so basically what happened then now is that because the local board added that that he could not return to Innovation Academy, which was really interesting because actually the district hearing officer said that he could in the transcript.
I don't know about ES, but I think the same general statement was made to SC during the hearing transcript indicates the same statement was made to SC.
Okay, and so then when he went to register, he was told no, he couldn't. And then he went to register at a zone school, and they delayed him for almost a week. And then after he had been not in class still for like 6 days, he basically got a schedule that didn't include the classes that he was needing to take in order to graduate, because essentially, in person, those are spring classes and they are not offered in the fall. So in order to graduate now and not have this go on another semester for him, delaying him going to college and delaying his career opportunities, he has elected to pay for one of the classes out of pocket. They allowed him to take one of the classes online through Georgia Virtual, but he has to retake the entire year of both of those two classes that he needs to graduate rather than just the second semester, because the only way it's offered in the fall is the full year in half the time. So he's basically having to redo fall semester of 2 classes that he had already completed and done well in, and then he'll be able to also get the spring semesters out of that course.
So will he be attending for the whole school year then, essentially?
No, it's condensed.
Just the semester?
Just the semester. So,
okay.
But he has to take the full load at his zone school, and he has to take that extra online class on his own time separately, and those are double the amount of work because they're doing them in half the time.
Okay.
By the time this was sorted out, he would have missed about 9 days of school, which in a double time class is a huge amount of time. So he was already playing catch up by the time this all got sorted out. So that's where he is right now.
Doesn't he allege he attended the classes or he kept up with his schoolwork, but that the district wouldn't let him sit for the AP exams? Is that?
That's correct. Yes.
Okay.
And they told him that
just sit for an AP exam.
Apparently you can, but you can sit in outside the county, but the county doesn't apparently allow any homeschooled students or students not at a district school to participate in AP course exams at a district location. He could have asked for a non-district location through the AP board, however that that organization is, but it had to have happened before November.
I see.
And they didn't get, none of this happened until January. So it was too late. Yeah. So he tried asking though and was not permitted. He won't be able to take those AP exams if he wants to go ahead and try to start college in the spring. He'll have sort of missed his opportunity. The only way it would work is if he takes the spring off and then does the AP exams in the spring. They're not offered in December, as far as I'm aware.
Okay.
So he's kind of out of luck with that. But yeah, this is clearly been a nightmare for everybody. Would you like me to continue with some of the various arguments? I think I'm just gonna have to highlight ones that have been brought up and where his piece sort of fits into that, if that's okay.
Yes, please.
Okay, so the first argument that we've talked about is jurisdiction. And the district, of course, attempts to claim jurisdiction over him for using school technology resources. And as we have talked about, those school technology resources are defined, and the definition doesn't include data or records. And as you know, Discord is not allowed on any of the school's devices. So again, he was not doing anything on campus. It was not with the school's computers. It's not with any of the school's other technology resources that aren't in dispute. But solely that GS was sharing student records that he obtained through the password and login to the school's server. So I would argue that the state board did get that right, that there was no jurisdiction over YH's actions. As far as the record violations, again, the tier 3 offense there's only one tier 3 offense. It's the only one subject to the escalation clause, and that's the one about copying computer programs, software, other technology. That's the first one that we all have sort of agreed that none of that happened. There's no copying of anything. Downloading of unauthorized files, there's no evidence that he downloaded any unauthorized files. And then using school technology resources for personal gain. We've again defined using school technology resources, as not including the files or data, but the personal gain issue here, I think, also needs to be reiterated in that the school has come up with this, or the district rather, has come up with this bullying piece. So basically, this I think is another example of where that anecdotal or information summary that Mr. Karishi created seems to have come in heavily against YH, in the sense that the administration says that he said something about having this call in order to talk about the behavior records of students that they were unhappy with. Actually, YH's own written statement says that they initiated this call to have a discussion over a faculty member who was doing some inappropriate things, and they were trying to discuss what the action should be, whether they should approach administration. And then the reason that this even came up was that GS said, well, hey, I'm in with the administration. I have access that other people don't have. And then he starts spouting off about the school discipline records. So it clearly didn't have anything to do with there being some sort of beef. It had to do with there being a problem with an administrator with a faculty member that they were all trying to decide what to do. Bullying, as you know, is a serious accusation, and there was no charges against anybody for bullying. It wasn't charged as its own rule violation, and the word bully doesn't come up in YH's multi-day hearing transcripts. So, all right, so the other differences were the other two offenses, as you know, were only tier 1. So they wouldn't have been able to be elevated to the tier 4 discipline measure. And so he wouldn't have been able to be either long-term suspended or expelled. And the first one, as I argued, has to do with the commands of staff related to technology. And the second one is that sort of catch-all for complying with the responsible use agreement. The way the district is interpreting that paragraph or that sentence at the end of the first one kind of makes it seem like it's actually repetitive of the second one, and basically just violating the responsible use agreement in some way, that they both sort of do the same thing, have the same effect. And as we've said, he's not being charged with any off-campus conduct, so it can only be referencing the student discipline records that GS and not YH accessed during the call on January 24th. And again, these were all things that were said verbally and not anything that was passed along. Okay, so then the Discord messages themselves, I'd like to, if that's all right, share my screen to show the ones that are relevant to.
Sure.
Sorry, I had I'm gonna stop that until I find the exact one. I had multiple screens up. There it is. Okay, I think you can see the screenshot. So hearsay. We've talked a lot about hearsay, and these messages, I think, are a really extreme example of hearsay getting in to a disciplinary hearing. The disciplinary hearing officer did say that any hearsay would have to be corroborated by non-hearsay evidence at the beginning of the actual hearing. So she clearly knew what the rule was. However, when this got presented, there was no I mean, my YH objected, but there was no objection, from the hearing officer. She allowed it. When you look at the way that this is done, we, as I said, did not have access to the full record. We did not know, of course, whose cell phone this was. We didn't know when these pictures were taken. They're not dated. We did not know who any of the people are who are mentioned as texting each other, or who's any of these usernames.
Well, in fairness, right? I mean, presumably YH is a party to this conversation. Well, not presumably, YH is at least use his username. The evidence was that he was a party to some of these text messages.
I don't think so. His name only comes up in a screenshot. That screenshot is this one right here, and it's done again in a much larger screen as well. I can kind of zoom in a little bit,
Right.
but his allegedly squarish rectangle.
Right. Yes.
The only time he comes up is in photos that are embedded into the text messages. He is not part of the text message group. He doesn't come in, and he's not text messaging any of these people. When we go drill down a little bit more, there are a number. Let's assume that this is the Discord deletions, and that they were on the 25th at 7:52, basically, or between like 7:45 and 7:55 in the evening. Then if we get to that point, then we see that he's deleted messages. None of them say files. They all do say messages. And they're by a number of different people, none of whom do we know are GS. Like, GS is not actually identified by any of the administrators, or in the hearing transcript, we don't actually know who GS is in any of these. There are a couple that we can kind of figure out based on, things that were said in parts of the actual text messages. Skittish Caddy, for instance, the Thor the Gamer God, we can kind of figure out some of those, but a lot of these are names that we don't know if they're people who were interviewed. We don't know if they were people who participated in the discussion or heard GS talking. We don't actually know that. Also, we can see that these are in specific threads, and the threads are none of them seem to be specific to school discipline records or talking about people's behavior issues with school. There's some that are general, some that are media, some that are cars. None of them seem to be specifically on the topic that they are alleged to be. And there's probably 24 of them. Here's the second page of it. And so they basically, it's like layered hearsay. So they have a photo of Discord, and then they have pasted that photo into their text messages, and then the administration has taken a photo of the phone that has the text messages. But we aren't given any of the information about who anybody is, or except for squarish rectangle, they tell them that this is YH in the hearing, but they don't ever identify any of the other people, and none of them are called to testify.
And
if they
forgive
had
me, Ms. Kirshner, maybe some of the documentation is running together for me that was in the different hearing files, but I thought there was some indication that we did know who Skittish Caddy was. And number one, and number two, I know I have seen screenshots of text messages that included squarish rectangle communicating with other people. Now, maybe not in the context of these downloads, but am I just completely, did I misread that entirely, or am I just thinking of a different part that you're not referencing now?
I don't recall, I honestly do not recall seeing anything.
Okay.
Sorry, that, let me stop sharing, that got a little bit weird. I do not recall seeing anything, and we combed through the text messages that were otherwise including squarish rectangle.
Okay.
Also, the hearing officer, YH objected. I was not present at his hearing. He
Right,
conducted
he proceeded pro se.
and for a high school senior, did a rather fantastic job, if I do say so, for maintaining his cool and getting through things. But at any rate, he objected to the fact that these text messages were coming in, and then the disciplinary hearing officer said that she was limiting them to the couple of pages that I just pointed out to you, that only those that were related to the deletions were coming in. Yet the whole pack that they sent to us then went into the full record. So I don't actually know if there's more than what was sent, what was included in our record. I mean, I guess that's possible, but as far as I know, there's no more with involving him. Okay, so as far as other hearsay, I think you've heard, from both of my colleagues that, that we're, saying that pretty much everything else in the files are either related to stuff that the administration has pulled together, or YH, well, in this case, YH's own statement. In this case, also GS's statement is admitted, but he is not called to testify. There's no other student statements except what's like we have not been provided with any of the other student statements, but they are allegedly incorporated into Mr. Carisci's summary and anecdotal.
Okay.
Okay, so that's something I wanted to point out on hearsay. Then you had mentioned about discipline, and I wanted to just add that Fulton touts that it uses a progressive discipline and positive behavior support policy. And in the code of conduct, it explicitly states that schools should make reasonable efforts to correct misbehavior through school-based resources in the lowest possible level, and to support students in learning the skills necessary to enhance a positive school environment and avoid negative behaviors. And then the code of conduct actually lists a variety of discipline measures that should be implemented to avoid removing a student from school at all. And some of those things are like writing an essay or taking an ethics course or doing a service project. But in this case, it appears to have only been lip service. They basically just went to sort of nuclear option with these students. And then I would say in order to treat students equitably, as was discussed, then expulsion or long-term suspension should never be the first discipline that any student receives unless they're a physical danger to themselves, other students, or teachers and school employees. And that's really what Tier 4 is describing, which none of our students are accused of. Tier 4 is designed to remove students who are potentially dangerous and a threat to physical safety. And basically what YH's discipline was that he was given is the same thing as if a student brought a gun or drugs or something like that to school or attack somebody. And also the progressive discipline policy says that prior behavioral performance is supposed to be something that's considered. And for all of these students, they have no behavior records. This is the first instance of anything. And in this case, of course, there was a minimal role that YH had in the situation. He's basically a passive as far as the phone, as far as the Discord call itself. And then he's deleting messages that ended up having nothing to do with actual student records, because whatever there may have been about that was already gone when he went on to Discord. Okay, let me see. I want to make sure I covered everything for you. Oh, I know. I did want to say a little bit more about the case that Ms. Waldman brought up that was about Goldwire versus Clark. Let me pull that up real quick. Okay, so as Goldwire versus Clark was mentioned, I just wanted to go a little bit deeper into that because I think it's really illustrative of my student's situation particularly. In this case, the student Clark was part of a group of students who were joking in the school cafeteria about calling 911 and reporting a bomb threat. And so basically they're joking about this on Monday of the week that this happened. Tuesday, one of the students was homesick, so they did nothing. On Wednesday, they're back to joking about this calling 911 and reporting a bomb threat. And when they get up to leave the cafeteria, one of the students actually does stop, call 911 and make this false claim. And they're all standing there with this student. And the school, of course, has to be evacuated. So Clark admits to being with the group when the call was made. And the court makes clear that it's not condoning or trivializing the bomb threat, but the court actually finds in favor of Clark, who did not actually do anything related to the bomb threat, that knowledge and presence are insufficient to demonstrate a violation of the rule. And in this situation, YH admits in his statement to deleting messages from Discord, but they weren't messages about student discipline records. And there's no evidence that any files were actually shared in the messages on that Discord chat. There's no evidence that he knew there would be an investigation on the 26th when he deleted messages on the 25th. And basically it's kind of the same thing. He was there and he was aware of what happened, but he didn't actually participate in what is really the problem, which is GS being able to access student discipline records. And so I just wanted to share that that case seems pretty similar in terms of what was going on, but there we have something much more severe in the facts of there being a bomb, an actual bomb threat.
Okay.
Okay, and then the last thing I wanted to highlight, I believe, is the sovereign immunity. And so the district has brought up sovereign immunity a few times, and this is, I think, particularly important for YH, given that he really does need to graduate this semester. He really desires, and I'm honestly kind of surprised about this given the situation and how hostile things have been, but he's really wants to graduate from Innovation Academy. He is dedicated to this school. He's volunteered, he's worked on the website, he's been like really an advocate for this school and wants to graduate from it. He completed the IT program at the school in his junior year. And, he really wants this on his record. He has to go about the process of reapplying to colleges, and he's going to have to explain the gap no matter what. But he really wants to be able to put this behind him, explain what was going on, and graduate from the school that he's dedicated to.
Yeah,
so
aside, that was one of the reasons I asked about his status, because at January of senior year with a student of that type,
Yeah.
I honestly was expecting that he would have already perhaps applied to various schools and been bound. So
he had to withdraw his applications the day of the actual investigation on the 26th. He was supposed to be meeting with an Ivy League school and ended up not being able to participate in that interview. So at any rate, these are all obviously really bright kids who have really bright futures. So the fact that we've gotten to this point and are, having them potentially not looking at the futures and careers that they thought they were going to have is just really frustrating, I'm sure. Okay, so as far as the sovereign immunity piece, though, basically I just wanted to reiterate for our students' purposes that sovereign immunity only applies to suits that are against the government. And in this case, as Ms. Waldman reminded, the district is actually bringing an appeal to the state board, but more importantly, the district initiated the case against YH by charging him with the violations and removing him from school. So they can't just turn around and use sovereign immunity to say, oh, you can't put this student back to the situation that he was in prior to the unlawful discipline action.
Right, but does it, so let's say I agree with you that I have the authority to do it. Ms. Waldman's argument was it doesn't really matter, because even if I were to end this hearing by saying I affirm the state board and I order the school to re-accept these students, they're going to appeal, almost certainly. And I guess I question whether if it's a close call, I should step out if that were the outcome, right? To order them to undertake something that won't solve it won't actually solve the problem for these students, assuming that I were inclined to agree with you.
Yeah, I guess it just depends how long it would add to the timeline. Because if you have made this ruling, then it's already on the record and we can go forward with whatever's needed to either try to re-enroll him and then be refused, and then, handle the case from there. Or if you didn't include that, then we would be, needing to submit. I am imagining we haven't walked through all of this yet, a writ of mandamus, and then we might have to then have a hearing for that. And then I can imagine that might be a longer process and that might ultimately still end up in an appeal. So
Right.
whatever, I'm
But
trying
that
to do
also,
whatever short is.
right. Well, but that also takes us right back to what we had a discussion about in the emergency hearing context was this issue that the district's position is that supersedious associated with the filing of the appeal as to these three students stays the operation and execution of the most current judgment that's under appeal. And so theoretically, whether it's because I were to enjoin or order or waive supersedious, right? I mean, we get into this problem of that seems like it's a larger function of the structure of how this is done that might be above my pay grade in terms of what the statutes provide for.
Yeah, I understand what you're saying. And the supersedious argument is really complicated in the sense that, as you know, from that hearing, I think all three of us would argue that that was never intended by the legislature to apply to school discipline. But as we're using it in this context and moving forward in this way, and maybe need a legislative solution there in order to address that, the question of which result is stayed seems to still be a question to me. And if we move forward another level of appeals, is this result stayed or is the previous result stayed? Like how far back do we go? And I'm not sure that has been decided. And so at some point, I would hope that the district would move forward with allowing these students to get back to the classes that they're supposed to be in and to graduate. And honestly, particularly, I would say ES is in the worst situation for this, given that she's right now either faced with not being in school or the alternative program. But YH is also faced with a really difficult situation, being that he really does need to graduate, and how, he's pretty interested in getting this off of his record because he really, believes that he did not do anything that violates the code of conduct. So I agree it is a hard question, and I think that's because it wasn't really ever intended to be used in this way, but here we are. So
fair enough, Ms. Kirshner. Anything else to add for now?
I'm sorry, just the end of my sovereign immunity argument was that we actually do have a contract, and I did attach it, and I hope I did this in the right way, but please forgive me if not. I'm volunteering. So if not, I can refile it in whatever other way. But the sovereign immunity wasn't raised until this level, so there wasn't anything in the record about the contract agreement between the students and the school for them to attend Innovation Academy. But they actually at the outset they had to apply, they were offered a position at the school, and there had to be an acceptance by a certain date for them to attend. So there actually is a contract. And when there's a contract, then the ex contractu clause applies, and there's a waiver of sovereign immunity. And the district uses this case about Tibbetts that basically, you may have already read it, but basically it's an employment contract that is in dispute. Tibbetts is a school teacher, I guess, or a school employee of some kind, and he does not sign the contract offer from the district by the time that the deadline passes. And he says that the offer was not complete which there is some statute specifically related to school employment contracts. And the district says, yes, it was. And so when it's basically reviewed, the court says, yes, that it was complete in the sense that what was left blank was Tibbets's personal information, his social security number, and his signature. And that the only other thing that was in dispute was that it was referring, instead of to an exact dollar amount, to a schedule of basically the salary schedule. And they said that that was complete enough, that that was a legit offer, and that he needed to have signed it by a certain date for it to have been a full contract. So there was no sovereign immunity waiver because there was no actual contract. But in this case, we actually do have a contract. So we do have a sovereign immunity waiver. And the last thing that they said that I wanted to highlight was that they said that the burden rests on the party that is bringing the sovereign immunity claim. And that is the district. They have raised this claim. So, and they have raised Title V, in fact, and put this into a question. So I feel like, that they need to bear that burden in terms of sovereign immunity.
Okay. Thank you, Ms. Kirshner.
Thank you.
Ms. Akins, Mr. Bryant. So I promised we've gone a whole big circle and now we're sort of back to where we started. About giving you an opportunity to respond and then to address any specifics related to YH that you feel like we didn't hit on earlier. Please go ahead.
Absolutely. I do want to rebut some specific points and arguments from each of the attorneys. But before I do that, I do want to also sort of mention that obviously I have not had an opportunity to read all of ES and YH's briefs that were submitted last night. I started ES, I think I got to page 6. And so I am largely responding to their oral arguments today. And we would ask the court for an opportunity to submit a reply brief, very similar to what we did for SC, so that we can respond to what's specifically in the brief, because I haven't read it as of right now. We want to reserve the opportunity to do that should the court agree. But then to turn specifically to, I'm going to start with SC, since that was who we heard from first. And, this next point, though, I think kind of applies to all 3 of these cases, in that everyone wants to sort of retell the story about what happened here. And there's a lot of information that's being shared that is simply not in the record. We are very much bound to what sort of facts are in the record, what was presented in each of these cases. There's a lot of back and forth about, well, it says it in this case, but not this student, and those sorts of details. And so one of the challenges of this, I think, for me, is to make sure I'm ensuring that each student's record is being considered individually. And I would ask the court, of course, to continue to do that whenever we're considering these issues, and to, not consider the story they're telling, but consider the actual facts and evidence that was presented in the record below. When we were discussing with SC, Ms. Waldman made a point or argument that how the records were sent to SC is somehow relevant, like what sort of, whether it was sent through Discord or whether it was sent through Google or Gmail or whatever manner it was sent. The reality is, in
fairness to Ms. Waldman, one of the reasons she was answering that question is because I said what I was unclear on from all of the reviews of these records, other than the reading out of the records, is it is to me unclear in the record how these records, to the extent that certain students are alleged to have had them electronically physically in their possession, how they were transmitted. And again, we're technologically, I am not nearly technologically savvy as all these students are, but I have an understanding of how that might go if it's email, or even if it's a text, but I have less understanding of how it might go if it was transmitted in Discord, specifically because there's some assertion that you can't access Discord from the school computer. And so in fairness to Ms. Waldman, the reason that issue, I think she was talking about it, is I had observed, and please correct me if I'm wrong, that none of the records are clear on how the information was transmitted to the students, like what media or method was used.
Sure. And 2 points there. Yes, to answer that first point, that the records are silent as to that. We don't know. The second point, though, SC's brief does raise that specific issue and does try to argue that SC only received them through Discord. And the point I want to make is that's not in the record. We don't know how those records were transmitted. I'm sure she's had conversations with her client, but that's not what's in the record that we can rely upon for the purposes of this appeal. We have to look at the information that was shared during the actual discipline hearing.
That is absolutely
Hang on. Ms. Waldman, I
apologize.
know clearly I'm guessing you take exception to what that statement is. I will let you have a moment to respond at the appropriate time, but let everybody was patient and let everybody talk. So let's continue to do that. Go ahead, Ms. Akins.
Sure. There was a lot of context provided in their brief and in the argument about how the records were transmitted. And my point that I want to make is that context isn't in the record. We did not hear from SC. She did not tell us how she received or did not receive. We just have what's in her written admission and what the administrators testified she told them. And again, that is what the hearing officer has to rely upon. And we have to ask, is that sufficient evidence to show that they violated the rule? There was also a question as to whether or not the notice was sufficient for the student. Notice issues under the state board are pretty straightforward. They have consistently held that the notice is not supposed to be an entire recitation of every single piece of evidence and fact that they plan to present at the discipline hearing. It's simply supposed to put the student on notice so that they can prepare a defense. And I think we can all agree that that notice that was provided to the student for SC and for all of the students, quite frankly, was sufficient for them to know what they were being charged with generally and be prepared to defend themselves at the hearing. It's not, like I said, there is no like formal discovery, there is no process or procedure or other requirements added, and the state board has consistently held that this sort of notice is appropriate. There was also a look at the discipline decision in SC. It was referenced in ES as well, about what the findings of fact were. And the findings of fact were that the students violated specific code of conduct provisions, those specific rules. There was also finding of fact that certain rules were not committed by certain students. But there is no long explanation as to what the hearing officer did or did not conclude, what was inferred, what was they agreed with, what evidence they weighed more heavily than others. They did not provide that information. They're not required to, and they didn't. And so we sort of just have to look at it on its face and ask ourselves, was there sufficient evidence to support the hearing officer's decision? And I know I keep coming back to that point, but that is the overarching point here that is most concerning. And then I also want to point out and remind the court that the strict rules of evidence don't apply in student discipline decisions. That is in the state regulations that we are bound to follow for student disciplinary hearings. So getting into the weeds about evidentiary rules is not really appropriate here. And the state board has...
I don't disagree with you necessarily, Ms. Akins, from the broad principle, but I do think it is notable, right? And this is to my own, I would have bet you, I would have said 85% that squarish rectangle text messages were in those chains, and I reviewed them multiple times, and apparently I was mistaken. Having said that, it is notable to me that there are no text messages in SC's record because there's no, and it was stated in the hearing that there's no record that SC was a part of any of those communications. And yet you have communications, there's no record of squarish rectangle YH being a party to it. And yet they're in his record and perhaps were considered by the hearing officer.
Yes, and the school makes a decision as to what evidence to present in their case. And quite frankly, I don't know what that process looks like. I was not a part of any conversations with the school about presenting their case at the discipline hearing. I don't know why they chose to provide certain evidence or not, but we really can't look at other pieces of evidence from other cases to support or not support the hearing officer's decision. We have to look at the evidence that was presented and the witness testimony that was provided during each individual discipline hearing and determine whether it meets that any evidence test. And again, we would again point out that there was sufficient evidence presented in each of these individual cases.
But as to SC, the state's, I'm sorry, the district's position is that the sufficient evidence was the statement provided by SC that she didn't know if the records were accessible on her computer because she had opened them on her phone. Which,
well, whether they were still on her computer,
right?
She doesn't say if she opened them or not. It is unknown. She didn't provide that information. We know she looked at them on her cell phone because she specifically stated that.
Right.
But again, we know they were on her laptop at some point in time. I do ask the question, how do you know they're on your laptop unless you actually looked at them? I mean, I think we do have to make some inferences here and ask some questions, but I think that's a very fair one, that how can a student say, I may still have records on my laptop unless she knew they were on there previously. And how would she know they were there unless she had looked at them, unless she had accessed them, unless she had downloaded them? And so that's, the inference that we would make. Again, I don't know specifically what inference the hearing officer made there, but he or she, the hearing officer, I believe it was Miss Perlman, was she, reviewed and listened to everything that was presented at the hearing and felt like that was sufficient to find her in violation of the rule. And that is reasonable here. All right. I also wanted to point out that there were some sovereign immunity arguments in Ms. Waldman's argument. And again, we would essentially say that any sort of waiver is kind of tied to the remedies that are available under the Appellate Practice Act. And so again, I know I've said this before, but the court is limited to affirming, reversing, vacating, or remanding with further instructions.
But isn't that, Ms. Akins, not a sovereign immunity argument, right? That's just I don't have the authority because that's not one of the available remedies. Right. I mean, that's different than saying, even though we sued, even though we're the ones that sought appellate review, that they couldn't, and perhaps the answer is that this is not the procedural model, right? This is not the procedural vehicle for the relief that they request, but that's a different argument than saying you haven't waived sovereign immunity as to anything because why? I mean, at least Ms. Waldman's argument is y'all are the ones that sued, so why haven't you waived sovereign immunity? And number two, Ms. Kirshner's argument is, yeah, there's a contract between the school and or the district, I guess, and all of these students, at least theoretically. I haven't, I don't, that's based on Ms. Kirshner's representation, but what of those two arguments?
Well, I haven't reviewed the contract to really understand what contract she's referring to. And she has not indicated there's been any breach of contract that I'm aware of. And that, I think, would be necessary here to determining whether or not what did or did not happen with this contract that exists.
Well, so let's take the easy approach on that one. The contract issue, while it might be an interesting discussion, isn't one that's presented here because it's not in the record. It's not okay.
It's absolutely not. I mean, it's not in the record. It's never been mentioned before. I have no idea as to the legitimacy of the contract. Is it complete? Is it not? I mean, I have so many questions about the contract myself, having not even seen it except for the 30 seconds that we just pulled it up during her argument. And so, this is not the appropriate time or place to get into those issues. We are bound to look at the issues that are outlined in our petition for review. And that is determining whether or not the state board's decision should be affirmed, reversed, remanded, or vacated. And those are the options that are available here.
Right. But also, what of Ms. Kirshner's argument that even if the court were, even if the court were inclined to say, you know what, I think the state board was right and the school board was wrong, I'm going to affirm the state board, right? But still, the district's position is, yeah, but because of the supersedious that attaches to the appeal, we don't have to give them the remedy that the state, how do and I know we touched on this in that original emergency hearing, and As to CS, I did not entertain. I know my understanding is that Judge Ingram formally or informally communicated, at least relative to, is it, I think ES's case, that she believed that the supersedious did apply, and therefore the judgment could not, the judgment was stayed. I punted and said, I don't think there's emergency relief required here, and so I'm going to let us get to this hearing. But we did discuss this issue. It does seem a little concerning that there's essentially no way for the student to get back. Even if a state board and a court said student is right, should not have been expelled, it shouldn't have been disciplined, especially, for example, in ES's case, right, where she is essentially not receiving an education, at least through December, unless she goes to the alternative school.
Well, Your Honor, the legislature is who set this out. And so I think we're somewhat limited to what the statutes say here. And that's kind of, we can get into the weeds about what they intended or didn't intend, but we need to read the statutes as they are written. And the issue is, from our perspective, stayed at this point. And whether there are bigger overarching concerns or issues really are, again, aren't relevant to this here, because we have to look at the statutes as they are written. And
well, I don't disagree with you. I mean, the statutes say what the statutes say. Just an observation point that it is to my mind, I know in the last hearing relative to CS, y'all, educated me that, this is, it sort of happens all the time, and this is what the procedure is, but it was surprising to me that that the structure was the way it was, in the sense of a student essentially having the state board say, no, the school board got it wrong, the student shouldn't have been disciplined, and yet still be functionally being disciplined. That's sort of, this is not, a money judgment or something that's just sitting there waiting for somebody to have their day in court. These are about minor children who can't be educated in the way that the school has, the district has the ability to educate them. That's just the larger issue that I can't resolve relative to what the legislature said. But
well, and I think, it's about whether the students are being educated in the way they want. Because again, the students have the right to be educated, and they are getting an education should they choose one. It's just not what they want it to look like.
I feel like we could argue about that all day long, because at least Ms. Kirshner's point, for example, for YH, is that he already has all the credits that the alternative school could offer him.
And Your Honor, and I was going to get to that, but I would strongly disagree with many of the statements she made about his ability to graduate. Mm-hmm. He had the opportunity to take classes to graduate on time, and he chose not to. They were not the classes he wanted to take. I think that is the difference here. Is he wanted an AP multicultural literature class or something of that sort. He did not need that class to graduate. He had other options. He just didn't like his options. And I think that is a substantive difference here, and that I fully recognize these students have specific courses they want on their transcript, or that they are interested in, or that they like, or, that they have whatever interest that is leading them to those places. But the reality is he was offered an opportunity to graduate, to earn those credits and graduate on time. He made a choice.
I'm not sure it's just positive of anything. It just, right. I think it's not as positive of anything, but I mean, I think it's clear. It's a point that bothers me, that the alternative school is not in a position, and I understand it. You're like, it's not the education they want, but it's not the education that this district says is appropriate for those students, which is why they provide AP classes and et cetera, et cetera. But go ahead.
All right. And I think I'm looking through my notes from SC. I do try not to respond to every little detail, just because I think that covers kind of the bulk of my response to SC. Next, I'll move to ES, I believe. Again, they made similar arguments about what the findings of fact did or did not say. And the findings of fact were that the student violated the rule. And so to add anything extra or take away anything really doesn't make sense here, because the hearing officer gave a decision. The hearing officer did not explain it in detail. I mean, we can all agree with that. But the reality is the hearing officer determined that they violated the rule. So we have to just turn and look at the evidence to see if it supports that outcome.
Right.
There
But
was some,
let me back up for a moment, because one of the things that I agree with you, that's what I agree with you and disagree with Mr. Adams when he says, for example, that the finding of fact that they violated the user response, that's a finding of law, right? I agree with you that that's technically a finding of fact by the hearing officer. But for example, been some, I understand your position is that 18E1, the cell phone policy, incorporates the IF, whatever that thing is again, the IFBGA. But on its face, I think that's one of the places I get hung up, is that on its face, at least, it's not as if the hearing officer said they violated this rule in this way, right? I find, as a matter of fact, that they committed this behavior and that's a violation of this. And so I think that's where I agree with you that they're allowed to say this policy was violated. But the cell phone policy to me is a good example, because it doesn't say because the IFBGA is incorporated here, they violated. It just says they violated. And at least on its face, the cell phone policy says, hang on, refusing to comply with reasonable directions or commands of school staff. And as Ms. Waldman pointed out, there's no evidence in the record that anyone directed CS, for example, or ES to stop using their technology in the manner in which they were using it.
I mean, there is evidence in the record that ES took a digital responsibility course. She took that class. She was instructed by Innovation Academy to use district resources and to use her district laptop in an appropriate manner. She was told that. That was the whole purpose of a digital responsibility course, is to teach her how to use those resources responsibly and ethically. And she violated everything that she'd been taught whenever she participated in this behavior. And so I would argue that there is evidence in the record that shows that she did act irresponsibly and that she violated what she'd been taught she was supposed to do. And you know, I understand that 18EI and 18II are very similar in that they both refer to that IFBGA policy. I fully understand that. But that is how the rules are written. And that is what we are kind of limited to here. We have to read the rules as they're written, and the hearing officer is not required to provide an explanation. They can. It is within the hearing officer's, discretion to do so, but they did not go into a detailed explanation of how the students violated each rule. And I agree, it probably would have been more helpful if they did, but they did not here. So we have to just look at it on its face and ask ourselves, okay, if this is what the rule said, is it a reasonable interpretation or understanding that the students violated it based upon the evidence that was provided? We can't, substitute our own judgment or interpretation. We just have to look at it reasonably. I mean, it's kind of like with the statements that Mr. Adams was making about Mr. Q's statements, whether or not his written statement versus his direct testimony, what do we believe? How do we weigh that? The hearing officer gets to decide how much weight to give the testimony of Mr. Q during the hearing versus the written statement from Mr. Q that was admitted into the record. The hearing officer gets to make that judgment call. We just have to ask ourselves, is the decision supported by that evidence? And we would say, again, it is. And then for ES, very similarly, there was a question as to what part of Rule 22A2, the encouraging misconduct rule, what part did she violate? Was it the incite, the urge, encourage, advise, or counsel? We don't know specifically because, again, the hearing officer didn't provide a long drawn out explanation, but the hearing officer clearly stated that she violated the rule. So we just have to accept that on its face and ask ourselves, is it reasonable to say that based upon ES's own statements, based upon what was permitted or what was presented during testimony of witnesses and what was presented in the communication she had with another student, whether it leads us to believe like, yeah, that's a reasonable interpretation and outcome, and whether the hearing officer's decision is supported by the record. And again, we would argue that it is. And then to respond to some of YH's arguments, there was some sort of complaint at the beginning about the administrators testifying about their investigation and the results of their investigation. Again, these discipline hearings are non-lawyers. They get in there, they have investigated an incident, and they've talked to multiple students, they've collected all of this information, and then they go in and talk about what they know and what they've learned. And if the student wants to clarify that further, if the student wants details, they have the right to cross-examine that witness. And if they don't get the information they want, then they can call other witnesses. They have the right to subpoena witnesses. They can call other witnesses. They could recall a witness if they so chose during the presentation of their case. They get to provide a defense, but they don't get to second guess the legitimacy or the accuracy of it because those folks are testifying under oath. And the administrator is not trying, the administrator was testifying under oath about what information he collected about YH, and we need to rely upon that information as true unless there has been some sort of alternative presented or impeachment evidence, and there wasn't. The student provided no other alternative viewpoint on that. There was also a mention about progressive discipline for students. The state does require that school districts use what we call a progressive discipline policy when disciplining students. A lot of people interpret that to mean if the student's never been disciplined before, then we have to look at the lowest level of discipline. That's not what progressive discipline means. It simply means that the discipline should be appropriate and suitable based upon the violation. If someone has zero discipline history and they bring a loaded gun to school, I don't think we, are going to just sit and have a parent-teacher conference. That is not appropriate discipline in response to that action. And the district has some discretion and the school has some discretion in determining what is appropriate whenever they assign discipline. And they use the code of conduct and the guidelines in that, the tier 1, tier 2, tier 3, tier 4 to guide them in determining that appropriate discipline. And so we would argue that progressive discipline was absolutely followed here. They considered YH's prior discipline, but for whatever reason, the hearing officer reached the conclusion that she reached for discipline for YH, and it is reasonable in light of the charges and the notice he was placed or put on for discipline at that time.
Ms. Akins, in terms of the notice that they were placed on, was the fact that the school was considering or was, I guess, departing upward to a tier 4 potential set of discipline sanctions? Was that part of the notice?
Yes, the range of consequences considered are included in the notice to the student. So they know what the possible outcome of the discipline hearing could be. They know that on the outset. So it's not a surprise as to what it is. And then they know what the school's recommendation is going to be. And so they can prepare their own recommendation for the discipline hearing officer, should they choose. And I believe YH did prepare his own recommendation and present what he thought would be appropriate for him. And I am quite certain the hearing officer considered that along with the school's recommendation and then made a determination that they felt was most appropriate under the circumstances of this student. I've already mentioned, that we disagree with the information about whether YH should be graduated at this point. And then the only other point that I think I want to make is there was some argument well, let me take a step back. YH submitted a brief last week that I did read they submitted an amended brief that I have not read, so I'm not entirely sure what differences there are between the two. But there was some argument and conversation about the use of admissions in discipline hearings and students who admit to certain conduct. And it is a long-held position of the state board that a student's admission in writing or to an administrator is sufficient evidence that they violated the code of conduct. I mean, that is a long-held rule of the state board. And so, you know, for there to be some sort of argument that now magically it's just not sufficient, it's just not reasonable under the circumstances here. And for many of these students, as I'm sure you've noticed, we have written statements and we have administrators' testimony that they don't conflict. I mean, a lot of this is pretty well aligned. The administrator's testimony might provide more context. The student's written statement might provide a different context, but they're not conflicting in any of these cases. They actually support each other more often than not. And so the admissions that the students make to their administrator or in writing are incredibly important. And I think were just unilaterally ignored by the state board. And again, it goes back to our original point that where there is any evidence, the local board's decision should be upheld. And so we would ask that you reverse the state board's decision for those reasons.
Okay. Thank you. Ms. Waldman, I may give Ms. Akins another chance to talk, but you had spoken up about one particular issue and I said I would give you an opportunity to respond.
Your Honor, it's almost as though Ms. Akins has not read SC's statement. SC's statement, which is what they're relying upon exclusively for her code of conduct violations, says very clearly, he sent me a file of blank student discipline records through Discord in a group chat. My entire record, probably in excess of 50 times, says the words group chat. To say that it's not in the record how she received this document is the most absurd statement that's been made today, and there are a lot of absurd statements. She got it in a group chat. That is undisputed and uncontradicted information. I have many things to say about supersedious, but that is not what I don't know that I get the right to.
Okay, thank you, Ms. Waldman. Mr. Adams, I'll give you the same courtesy if there was anything specific very briefly that you wish to address. And you're muted, Mr. Adams.
I appreciate it, Your Honor. Because Ms. Aiken brought up the importance of sticking to the record of each student, I will point out that in the record for ES, there is no evidence that I'm aware of her deleting any messages. So that's point one. Point two, Ms. Aiken brought up this digital responsibility course, I suppose as an example of a directive that was not followed. There was a reference, I just checked, in the transcript for Mr. Kent referencing that there was some kind of course taken. We don't have that course. We don't have its syllabus. We have no idea what they talked about. We cannot possibly say that was a directive that was not followed. And finally, on the encouraging misconduct, I still did not hear in Ms. Aiken's presentation, and I still don't know what it was that was the rule that ES was encouraging somebody else to violate. That's all I have, Your Honor.
Okay, Ms. Karshner?
Yes, Your Honor. I did want to say that in regards to the compiled statements and oral supposed admissions that Mr. Creasy created his anecdotal summary out of, Ms. Aiken says that it's long held that should be able to be used as the source of the admission. But in this case, there were very many students who were participants in this Discord call. Several of them were interviewed. Mr. Creasy used all of their supposed statements and supposedly also oral discussions with their parents, but then did not share who those people were or which students said what. So it would be very difficult to call them for YH to then call them and asked them about their statements and which part of what was said is what they allegedly provided.
Right, but,
Another,
well, hang
sorry.
on, let me back up for a moment. I mean, certainly administrators, just as police officers do, frequently testify, I conducted an investigation and this is what I learned. Now, if what they learned is so-and-so told me this, that's a different issue. But if they say, I conducted an investigation and I learned that these 5 students had done X, right? That's perfectly within his purview to testify about. And he was subject to cross-examination about the nature of that testimony. Granted, he was being cross-examined by an 18-year-old, albeit a very smart one. But he was subject to cross-examination on that issue. So why wouldn't that be sufficient?
Well, I was about to say that the cross-examination, I think, demonstrated that it wasn't necessarily his own statements that were being used to support the outcome that the hearing officer supposedly came to. For example, Mr. Kent had quite a long description of what he thought the call between GS and YH was about on Thursday night, the 25th. But then when he was asked to actually talk about that, his statement suddenly becomes much shorter and is basically just the same as what the student has said. So he's basically hypothesizing based on what he thinks has happened. And that has been like included into Mr. Qureshi's investigation. And so I think, yeah, that's what I wanted to share there. And then as far as the progressive discipline, I think it's also really important to note that Mr. Kent was asked by the student in regards to the student's the recommended punishment for the student, and Mr. Kent said that the discipline was that they decided on was to send a message to others. And that's not really what the discipline is supposed to be about. The code of conduct is pretty clear that the discipline is supposed to be only as much as is necessary as to correct the behavior of the student who is doing whatever behavior it was. So providing discipline that is, or imposing discipline that is in order to send a message to others is an inappropriate use of discipline.
Understood. Ms. Akins, it's y'all's petition, so you still get the last word.
I guess I'll go in reverse order there to respond to Ms. Kirshner's comments there. At the end of the day, that there is no evidence that the hearing officer's decision with regards to discipline was somehow inappropriate or not within the confines of what the code of conduct allowed for. And that's the question here. I mean, certainly what Mr. Kent did or did not say was considered by the hearing officer, but that does not mean that that was the linchpin of the decision, so to speak, because we don't really know what the hearing officer relied upon. They heard all of the evidence that was presented and felt that the discipline that was assigned was appropriate for YH in that particular situation. Turning to Mr. Adams' comments, the encouraging misconduct issue, it's interesting because ES has violated all of these code of conduct rules and is encouraging other students to hide or delete or access private student information. And we know that she violated the rules because of her own use of that information. And so giving others the access and ability to do that as well is part of where she violated this rule. And then by just refusing to work with administration, I mean, in her statements, she says she's not going to talk to administration. So I think we can kind of wonder, would she have ever had conversations with administration about everything that had happened if they had not sort of found her first?
Right, but Mr. Adams' point is not, it's not what she did or how she did. I think Mr. Adams' point was, if the rule says you can't encourage misconduct and you are hereby found responsible for having violated the rule that prohibits encouraging misconduct, that what the school district has not done is said, what misconduct did she encourage? Is it that, and this is why I continue to ask that question, is if what she was doing was telling people to delete the data, right? if that's not a violation, then what misconduct was she recommending people to engage in?
To destroy district data, their resource that belongs to the school district. She encouraged them to destroy that, to damage it, however you want, whichever that terminology you want to use from a digital standpoint, because I recognize we're not balling up a sheet of paper and throwing it in the trash, but she was recommending that we destroy that, or that they destroy that. She was recommending that they, or she was giving them access to these stolen records. By giving someone moderator permissions, it gives them access to whatever is on that server. So now they have access to whatever was or was not shared. And again, that goes back to the point of, were the records shared on Discord? Were they not? Were they in direct messages? Were they shared with everybody? I don't know, but she just gave other people access to that information, to any records, to that documentation. She was releasing that unauthorized information to them, which is a violation of the district's IFBGA policy, the operating guidelines. I mean, it's a violation of the rules she's already violated herself. And so she was conspiring with others to violate and continue to violate those rules. So that's what we would respond to with that.
Okay.
And in response to Ms. Waldman's argument about what SC statement actually says, it refers to the records that were shared on Discord. We still don't know how and when those records were shared in the months prior. We know that she had access for a period of time. That is in the record. We don't know specifically how and when and the details surrounding that. It's simply unclear in the record, but that doesn't mean that that's not sufficient information to find that she violated the rule.
Okay. Anything else, Ms. Akins?
I don't believe so. I did want to circle back to our question about whether we would be permitted to file reply briefs for ES and YH.
I generally, I mean, I am going to let you do so, but I will just remind you that I generally, I generally prefer that they be true reply briefs, let's not rehash everything. And this was done on an expedited basis for a reason. So, I would, today's Monday,
Sure.
Thursday.
We can do that. Thank you, Your Honor.
Okay. So let me say a couple of things. I'm obviously going to wait for the briefing. I want to go back and look at the record, but let me say a couple of things. Number one, my personal opinion is that the reason we're all here is because the perception, whether it's the school board or the students or whatever, is that, or not perception, is that perhaps the punishment was draconian. Now, whether it was appropriate or not, it can be as draconian as it wants to if it's appropriate. I'll also say that I don't think there's any, to my way of thinking, it's clear to me that these students had an understanding that what they'd done was wrong in the moral sense. Whether or not it is prohibited by the school's conduct code is the larger question. And I, as I said, I understand, as much as some of the questions may have indicated that I was very interested in things that are probably not dispositive of the outcome, call it the rule of judge's interest. But I understand my role is to look at what was, whether or not the finding below was supported by any evidence. In this context, I will tell you, I do not intend to deal with the request for some sort of injunctive or declaratory order that requires the students to be returned to the Innovations Academy. And that's even if I reverse the state, even if I affirm the state board, without getting into a discussion of sovereign immunity, I don't think that I have the authority inside this case to order the implementation, the return of those students to Innovations Academy in this procedural vehicle. So all of that is a long way of saying this. I'm going to go back and look, and wait for the briefing, the additional briefing that the state has requested, excuse me, that the district has requested permission to file. And consider whether or not there was any evidence to support the decision by the school and the supporting of that decision by the school board, and whether or not I will affirm or reverse the state board's decision that the conduct, either or both, was not, that there was no jurisdiction in the code of conduct for the alleged wrongful behavior by these students, or that if the code of conduct did apply and give the school jurisdiction over the alleged actions, that those alleged actions were not violations of the code of conduct. And so that's what I'm going to focus. I think that's what I'm supposed to focus on. And so that's what I'm going to look at as soon as I have the additional briefing. What I typically do, just so you'll know what to expect, is, and I'm going to try and do it on an expedited basis because I understand there's going to be appellate and or other actions taken by probably any number of the parties in whatever direction. So I will try to be as efficient as I can in getting a ruling to you. What I typically do is I will advise the parties by email that this is how I'm going to rule, and ask for the party in whose favor I'm ruling to provide me with a proposed order. Now, I typically rewrite them fairly significantly, but at least I have found that it is a much easier way for me to make sure that I'm catching the issues that were relevant to my decision-making process. Any questions, issues regarding procedure or other issues I need to address before we adjourn? Ms. Akins?
No, Your Honor.
Ms. Waldman?
No, Your Honor.
Mr. Adams?
No, Your Honor.
Ms. Kirschner?
No, Your Honor, thank you.
Okay, excellent. Thank you all for your time and for the just in-depth discussion. And I will look forward to the state's the district. And also, Ms. Akins, just to add one more point, my standing order does have a rule about reply briefs. I think there's a page limitation in there. I haven't looked at it in a while, so you might want to take a look at that just to make sure.
Yes, Your Honor. Thank you.
Thank you all. Have a good day.